Hi, everybody coming in. We are going to be talking about Chiles versus Salazar today. It's a sort of like interesting case coming out of the 10th Circuit, revolving around this premise idea of sort of like conversion therapy. And we shall see what is going to happen with this. Give me one second. But yeah, we're going to be talking about this case today. Hoping people will come in for it. So Chiles versus Salazar revolves around whether Colorado's law what is it called? Colorado's minor conversion therapy law, passed in 2020, bans licensed mental health professionals from practicing conversion therapy on anyone under 18. Conversion therapy is any counseling that aims to change or suppress a person's sexual orientation or gender identity. And breaking it could cost a counselor their license. Now, Chiles has sued, saying that she's a licensed professional counselor who's also a licensed minister, and she is suing the state because she wants to be able to talk to her underage clients about their sexual orientation or gender identities in ways that encourage them to align with traditional views. Now, why does this become problematic? So when you're dealing with children, their sort of identity, right, is centered with their parents. Now, if their parents book this session with her, what is the outcome here, right? Like if this child identifies as gay, gender fluid, things like that, what is this sort of outcome? Is Colorado right, or does it suppress Chiles' freedom of speech? This should be starting here in just a few minutes, but since yesterday I started a little later and didn't really get a chance to update on the case that was going to be covered, I wanted to start earlier. The actual question in play, give me one second, is whether a law that censors certain conversations between counselors and their clients based on the viewpoints expressed regulates conduct or violates the free speech clause. So this is really sort of very interesting. This is a First Amendment claim saying that Colorado's law is in violation of Chiles' free speech and other counselors who want to practice this. Now, on a moral level, I certainly think that Chiles' conduct is likely problematic. However, on a legal level, it could indeed be suppressing her freedom of speech. So this is going to be interesting to watch play out. I'm sort of curious as the arguments that they are going to make. And I really don't know yet. I'm fairly certain that just based on the leanings of the court, they're probably going to perceive this as a violation of her freedom of speech. But again, it's a sort of just because you can do something doesn't mean you should. Kids, we know, especially for kids that question their gender identity, better outcomes are had from going through the WPASS standard, transitioning. And this is sort of interesting in the context that I had never thought of like conversion therapy as like a one-on-one session. I always thought of like those like camps, those overly religious places that they send people to. But this is actually quite interesting. I think this is likely going to be ruled as a violation of her freedom of speech. However, we shall see how the arguments go. We're starting in about 2 minutes with arguments, so we shall see. if anybody has any questions, pop them in the comments now. If you're not aware, I cannot pause oral arguments when they are live. So if I have to pause and answer your questions, it could skip some of whatever's going on in the court. But yeah, I'm a little bit curious about what they're gonna do. Let's see. And Chile is backed by the Alliance Defending Freedom, a conservative group that fights for religious freedoms. Oh, wait, let me share this with my pookies. Hold on. There we go. Okay. And then tomorrow we're going to do Boss v. Board of Elections, which will revolve around whether basically they can regulate the state manner and time of their elections. Riley, go tell Davo to get his ass in here. I need a co-host today. It's too hard to do this shit by myself. But yeah. So we shall see what is, oh, you know what? I think he has school today. Never mind. But anyway. Yeah, this will be interesting because although I think that it's potential that this could infringe upon her speech, we're also talking about medical practices and procedures here. So where it's kind of where is that divide going? Where are we seeing this sort of like, at some point you've got to be able to tell doctors that they can't, i.e. like something like saw a foot off instead of, you know, maybe trying medication therapy to get circulation back. So I'm wondering where this is going to go. I'm quite curious. But yeah. Oh, let's see if they're on. Give me one sec. What the shoot? Hold on. I may have to refresh it today. There we go. Okay, there we go. Let's see. These should be on soon if they're not on already. But yeah, again, today, this is sort of the conversion therapy case. At what point does Colorado's law saying, hey, you can't do this, infringe upon a therapist's views and rights? Hey, Kevin. And just to be clear, like, in the legal system, this is not whether you morally agree with something. This is not centered around how you feel about something. This is centered around what is the law and how do we interpret this law. Technically, this is a First Amendment claim, so really, this is interesting. Can the government regulate the way that a therapist communicates with their clients? I think it becomes even more tricky because this is a case that revolves around minors. Minors are represented by their parents, not themselves. Now, like when you go through the cert petition, the cert petition is like, yeah, you know, she has a conversation with these clients. If they're comfortable with their beliefs, you know, she's good counseling on where they're at as a person. However, it doesn't inherently work the same way with minors, because when you take your son or daughter to therapy, the parents have a little bit of undue influence on this. Maybe they shouldn't, but they do. So Yes, this is about Colorado's law regulating, sorry, I keep forgetting the name of it. Colorado's minor conversion therapy law passed in 2020. It bans licensed mental health professionals from practicing conversion therapy on anyone under 18. Conversion therapy is any counseling that aims to change or suppress a person's sexual orientation or gender identity. Breaking it could cost the counselor their license. About 20 other states have similar bans. So they're going to be evaluating this today, and whether, since this counselor is religious and practices as such, whether this violates her freedom of speech. Yeah, it is tricky. And that's the thing, is like, at the end of the day, I can morally disagree with what they're evaluating here. I can think that conversion therapy is gross and wrong, but it matters on a legal standard of whether this is suppressing her freedom of speech or whether it's not. How far is too far? Where does it go? So, oh my God, are they gonna start anytime today? Hurry up. Hold on, let me check YouTube. Sometimes the Supreme Court website don't want to be cooperating. Hold on. Go away, allow. Supreme Court oral arguments. Let's see what we got. Let's see. Let me refresh it one more time. See if we get anything. I'm not even getting like background feeds, so Supreme Court oral arguments. Chiles v. Salazar. Let's see what we got. No, I don't want to do that, stupid Washington Post. Let's see.
We will hear argument first this morning in case 24-539, Chiles versus Salazar.
Hold on.
From helping minors pursue state disfavored goals on issues of gender and sexuality. This law prophylactically bans voluntary conversations, censoring widely held views on debated moral, religious, and scientific questions. Aside from this law and recent ones like it, Colorado hasn't identified any similar viewpoint-based bans on counseling. These laws are historic outliers. In NIFLA, this court protected professional speech, highlighting the dangers of censoring private conversations between professionals and their clients. And this court rejected by name 2 lower court decisions upholding laws like Colorado's. But the 10th Circuit gutted NIFLA's speech protection. Colorado insists that its law is subject only to rational basis review. Yet that would allow states to silence all kinds of speech in the counseling room, such as disfavored views on divorce or abortion.
Thank you to everybody coming in. This is Chiles versus Salazar, conversion therapy in Colorado.
Counselors into mouthpieces for the government. Here, Colorado can't satisfy any level of heightened scrutiny. It didn't seriously consider any less restrictive alternatives.
Oh, is everybody good on audio?
Colorado can't prove harm because it hasn't cited a study focusing on what's at issue here: voluntary speech between a licensed professional and a minor. Nor can Colorado deny that many people have experienced life-changing benefits from the kind of counseling that Ms. Chiles wants to provide. The First Amendment doesn't permit Colorado's censorship. I welcome the court's questions.
I think that's probably going to be the outcome.
In its introduction of its brief, Colorado says that the only thing that the law prohibits therapists from doing is performing a treatment that seeks the predetermined outcome
This is
of
Thomas.
changing a minor's sexual orientation or gender identity because the treatment is unsafe and ineffective. One, is this what Colorado argued below? And two, is that your reading of the Colorado statute?
Colorado took a different position below in its motion to dismiss, specifically footnote 3, and on page 10 of its opposition to the motion for preliminary injunction. It recognized that efforts to change unwanted same-sex behavior or to reduce unwanted same-sex attraction would indeed violate the law, and that's contrary to the position it's taking now. I do think if we look at the plain language of the statute, we will find that what Ms. Chiles alleges in this case falls squarely within it. The statute says that there can be no efforts to change sexual orientation or gender identity, including efforts to change behavior, gender expression, or attraction. On page 207 of the petition appendix, Ms. Chiles alleges in her verified complaint that sometimes she helps clients who want to reduce unwanted same-sex attraction, change unwanted same-sex behavior, and to resolve dysphoria that they're experiencing with their bodies.
Counsel,
all of that.
You are right that that fits the definition of the law. But we have been very clear in Susan B. Anthony that there has to be a sufficiently eminent and credible threat of prosecution. We've said merely having a law on the books is not enough. A chilling effect doesn't exist. This is an unusual case because we have basically 6 years of no enforcement of this law, 3 before this lawsuit, 3 since. And we have the entity charged with administering the law saying we're not going to apply it to your kind of therapy. So how does that fit into being an imminent threat of prosecution? Yes, you have an argument. They've disavowed it. How does that give you standing?
I don't believe that the state has disavowed enforcement. The state is relying on a misreading of the allegations in this case to say that there's no standing, but they have not disavowed enforcement. If Colorado truly believed that it wouldn't enforce the law and that Ms. Chiles wasn't...
So tell me what kind of disavowal you would need to find no standing. Would it be sufficient to say that consent, which is what your complaint claimed, that your therapy is consensual talk therapy, where you would seek to change
I tried to turn off my Discord notifications. It won't work.
Of a child only if that's what they want, correct? Am I articulating it correctly?
That is certainly an aspect of what Ms. Chiles
I don't want
alleges.
an aspect. Define your talk therapy, and then when they get up, they can tell us whether they're disavowing any enforcement of that kind of talk therapy.
I would go back to what I referenced before, which is petition appendix page 207.
Counselor, please answer my question.
I am trying to answer
What is your
question.
talk therapy, and that you want them to say they will not enforce it against?
Ms. Chiles helps clients when their goals are to resolve gender dysphoria by getting comfortable with their body and realigning their identity with their sex.
Goals.
She also helps them if
their
they're
goals,
experiencing unwanted
necessarily.
same-sex attraction, if that's their goal to reduce it, and she helps them deal with issues of unwanted same-sex behavior. That's the kind of counseling that we've alleged in the complaint. And here there's
Would
a credible...
any of that include what's talked about as aversion therapy, which is encouraging them to vomit, encouraging them to go into electric shock treatment, encouraging the typical aversion therapy?
No, Ms. Chiles does not do any of that. All she does is speech in her counseling.
And does that, so what behavior
But
does
that
that
is a good
include?
question. Where do you draw the line?
Date other people of your
No,
the opposite sex?
No, she does not. That's not the kind of counseling she engages in. She engages in a discussion where her and the clients explore the concepts of identity,
So
behavior.
go back to my last part of my question. If they disavow enforcement of that kind of talk therapy, do you have standing in this case?
We still have standing in this case. Over the last few weeks, There have been anonymous complaints filed against my client, and those complaints are now being investigated by the state of Colorado for allegations that she's violating the very law that we're challenging. So we had a credible threat of enforcement before because there's no disavowal. Anyone can file a complaint at any time, which this court recognized bolsters a credible threat of enforcement in SBA list.
Or does it have to be a client?
That the state is actively investigating our client for supposedly violating this law.
Okay.
Well, that sounds like a problem in Colorado's law. They need to be a client.
Then they won't be investigating.
But regardless, if they disavow, it's only based on not only a misreading of the statute, but also a misreading of the allegations in the complaint. As we pointed out in our reply brief, there are often uses of portions of quotes. And the state of Colorado is ignoring the rest of the sentences in the allegations. Once those are read, just as the lower courts found, there is standing in this case.
Counsel, how does your position change if, in addition to the counseling, there is more, what I'll call medical treatment, whether it's medications?
Bro, there are
shots,
so many amicus briefs in this. All I could read was the cert petition.
It certainly does alter our position. So as this court
There's
talked
at
about
least
in NIFLA, when
50
speech
plus.
is incidental to regulated conduct, then that changes the analysis. And so if we were in the medical context
reading all
and there
those.
was something like administering drugs, performing procedures, conducting examinations, that would take it outside of the arguments we're making.
How about if
into a
it's just
different bucket.
both? In other words, the speech isn't incidental to giving somebody a
Thank you,
prescription
everybody
for
coming
medicine.
in. Please tap the
It's,
screen.
It's speech and it's giving somebody
like
a
fill up a
prescription for
bar.
medicine.
It would depend on how closely connected they are. So if the speech is describing how to take the medication, then that would be incidental.
Right, but if the speech is the speech that your client engages in, and in addition, she engages
Why would that be
in
incidental?
something that's non-speech, would we look at it separately or would we look at it as a package?
If they're sufficiently disconnected, I think you
I'm
would
not
look at them
sure,
separately.
Wallace.
And
I
my
have to
client
look.
doesn't have the authority to prescribe drugs
may be able
because
to.
she's not a psychiatrist. And the
there
state
it
of
is.
Colorado recognizes that there's a very big difference because it treats psychiatrists under Section 240 of the code and it treats counselors under 245. And that's a recognition that it's just different regulation when medicine is at issue. In this case, Colorado is violating the promise that this court laid out in NIFLA, which is that states should not manipulate private conversations between licensed professionals and clients. Beyond
So how
that,
would this apply to a malpractice suit? Let's say that we think that this is content discrimination and it triggers strict scrutiny. Would your client then be subject
Sorry,
to a
guys.
malpractice suit?
she would be subject to a malpractice suit, but she would have the protection of the rigorous elements of malpractice. She would be able to show that she's not violating the standard of care, that she would be able to establish what the standard of care is. She would be able to show there's no harm and there's no causation.
Well, I assume there would be a battle about the standard of care with, competing experts, competing medical associations. Colorado's pointed to some professional associations in this case. Would the First Amendment have anything to say about that? I mean, would it be strict scrutiny? I mean, it's the elements of a tort. It's a different thing. We didn't get to this question in Snyder.
As a general matter, the elements of a malpractice suit are sufficient to protect freedom of speech. Now, I'm not willing to foreclose the fact that there might not be an argument someone might make in a particular malpractice case. But for our purposes, the elements of malpractice are generally sufficient to protect free speech. And in this case, the court doesn't need to resolve whether there might be additional protection. Because the way that Colorado is using malpractice is as an analog to what it's doing here. But it's nothing like
Well,
the law that
I
we're
wasn't
challenging.
actually asking about the analog argument. I was just asking it independently. So
Can I just
I
ask
took
you
you
to...
to say
Oh,
on
Coney
page
Barrett,
18
yes.
of your reply brief that in fact a malpractice suit could
I thought you
go
meant
forward
James Comey.
and completely separate from the First Amendment, what you need to prove a malpractice suit provides sufficient protection. Is that a right reading of what you said?
It is a right reading, although we said that those elements are generally sufficient. So I don't want to foreclose that in a particular case there might be an argument, but generally speaking, a malpractice action subject to the rigorous elements would be sufficient to protect free speech.
Can I get you to address whether or not the provision of therapy and the
Jackson.
kind of therapy that your client practices is a medical treatment. I mean, I understood the sort of basis of the 10th Circuit's view to be that she's a licensed professional who is providing medical treatment, but your answers to the Chief Justice and Justice Kagan suggested that you're putting the practice of medicine on one side and her therapy on another. So I'm just unclear as to whether or not you're categorizing
And at that
her
point, they
therapy
cross
as a medical
over,
treatment.
right? Like they're crossing
I
over.
don't believe that we are categorizing it that way, but I don't think it matters because the First Amendment depends on the difference between speech and conduct, not on the difference between treatment and non-treatment. So in my response to
But I
Chief
guess the
Justice-
argument that the 10th Circuit seemed to find persuasive was that if you are in the world of medical treatment, you are regulating conduct, that the medical treatment itself
It's both
is
here, right? Like therapists,
an
because
activity
they're medical
that is being
providers,
licensed and that is being
like
performed,
they are a version
and that
of medical
it really
provider,
isn't
but
speech,
it's
that
talk.
speech
It's
is
still
the
both.
tool that is being used, just like in other medical treatments. You have scalpels, you have tools that medical professionals use to accomplish certain goals and to provide treatment. And so in that sense, I think their argument was
Please
that
keep tapping,
speech
guys.
is incidental to the provision of this medical treatment. So I guess we need to understand whether her therapy qualifies as medical treatment.
The question is whether her speech is incidental to conduct. That's what the court said in NIFLA. It said that if there's professional conduct, then speech that's incidental to that could be
So
regulated.
treatment
But
is
here-
not conduct in your view, medical
If
treatment.
the treatment consists only of speech, then it doesn't trigger the speech incidental to conduct doctrine. And here we're just
I
in
wouldn't-
First Amendment land where there is full, robust protection.
I wouldn't agree with that.
That's why I answered the Chief Justice's questions differently and acknowledged that if there was conduct in the practice of medicine going on, it changes the
But I guess it
analysis.
seems very odd that you could have two scenarios where you have two licensed professionals both attempting to provide treatment to an individual,
Everybody
say
coming
for the
in,
same
we'll listen to
issue,
conversion
that,
therapy
the
case with
person
the
says,
Supreme
I'd
Court."
like to live consistently with my biological sex. I feel that I'm not doing that. I'd like your help. Medical professional A treats that quote unquote condition with medication. Medical professional B treats that condition with talk therapy. And I guess under your theory, those two scenarios are sufficiently different from a constitutional
I think
perspective
I may go
that one could be
5-4,
allowed and
Lawless.
the other not.
I think this may
I
be a
think that's potentially
5-4.
correct because the First Amendment would apply to the speech.
Just
only
because
therapy.
words are being used to accomplish the
I
therapy.
think Roberts
in
is
one
more likely to
scenario
dissent in this
and
one.
not the other.
No, because only words are being used in the one scenario. Again, if there is a combination of words and conduct, I think that takes us into a different realm. But one of the things that's so problematic about Colorado's law is that it undermines the well-being of kids that are struggling with gender dysphoria. And so Colorado accepts
How?
that up to 90% of kids who struggle with that before puberty will work their way through it and realign their identity with their sex. But this law says that if any of those children
Where'd
go
those
to a
numbers
licensed
come from?
professional and say, I would like help realigning my identity with my sex, that licensed professional has to decline to help them. On the other
Does the
hand,
analysis apply if the law is not this law? I think Colorado has something like the law I'm going to describe, but I'm not trying to describe Colorado's law. Just take it as my hypothetical. If instead of this law, which really focuses on the kinds of treatment it is and the kinds of goals everybody has, it just says you're subject to penalties if you do any medical treatment, and that includes talk therapy, that deviates from the standard of care. And then it goes on to say something about how we find the standard of care. And suppose that sort of law was applied to your client. Is it the same analysis or a different one?
I think it's a similar analysis. So if a law like that were applied against my client and all she did was speak, then I believe that the strict scrutiny analysis would apply and the government would have to satisfy it. But the underlying analysis would change somewhat too, because my client under those circumstances would be able to establish that the kind of counseling she provides is consistent with the standard of care versus under the current law, she's not able to make that showing.
Right, so she is able to make that showing under my hypothetical law, but you're saying still not, that she would have a kind of separate argument that there needed to be strict scrutiny applied.
She would. She would be able to argue that, and that would require the other side to show that what she's doing is causing harm, because that ties into what this court's recognized in cases like Brown under strict scrutiny.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
Counselor, in your introduction, you appeared to be applying strict scrutiny. One of the factors you said is the state has not pointed to a study that shows that talk therapy is harmful. I don't believe strict scrutiny always requires a study. I mean, look, I'll give you a hypothetical.
It's supposed to be 45 minutes,
A
but
state tells dietitians
sometimes it don't work out like that.
encourage anorexic patients to engage in more restricted eating. All right? I don't think the state has to provide a study to show that
This is not the Brunson lawsuit. This is Chiles versus Salazar.
Do you agree?
And the
Justice
Brunson
Sotomayor,
lawsuit
I
didn't
think
make it
that
anywhere.
might be true, but that's because that kind of hypothetical is very different than what we have here.
So explain the difference.
In that hypothetical, the counselor or dietitian is telling the client to do something that directly harms their body. In this case, Ms. Chiles is trying to help gender dysphoric kids.
That begs the question, because there are studies that say that this advice does harm the people emotionally and physically. But putting that aside, you agree then that you don't always need a study. An absolute statement like that misstates the law.
No, what I agree is that if what the state is getting at is a statement by a professional that's telling someone to harm their body, that's a different category.
They were rejected
but if
by
we're
the
in a
Supreme
situation
Court.
like this, where there is debated science, where the counselor
Brunson
is
case.
trying to help the child achieve their goals, then absolutely the standard this court set in Brown would apply, which requires a showing of causation.
So there's only one circuit that has applied strict scrutiny to this kind of thought therapy. It's the 11th. The others, the 9th and the
Hold on one
3rd,
sec, guys.
have not. You seem to be encouraging us to apply strict scrutiny here. And the question I have, we're not a court of first review on this issue. Why don't we send it back? I'm assuming that the 3rd and the 9th didn't apply strict scrutiny because they thought they'd have a problem with applying it to this law. Why should we be breaking our normal pattern in this case?
Because there is ongoing harm every day. Ms. Chiles is being silenced, and the kids and families who want her help are unable to access it. It's very similar to what this court did last term in the Mahmood case, where the 2 lower courts had decided the case on rational basis review, and when this court decided that strict scrutiny was the proper
Remember,
analysis.
Justice Kagan?
Sorry, guys.
Do you think if there were the exact opposite kind of law, so this is a therapist that, consistent with the child's goals, is trying to get the child, to accept a gay identity or a trans identity. So it's exactly the same statute, but it's just flipped around. Same argument?
Strict scrutiny would apply to that unless there was conduct involved. If there was conduct and that conduct was unlawful, then the speech integral to
now
unlawful
there's conduct
doctrine would apply.
involved.
But if it's
Now
only
there's
speech,
conduct.
then yes.
Wait, I'm assuming that your caveat, unless there was conduct involved, applies to your case as well, right? That applies symmetrically to both, unless there was conduct involved that was of that kind.
That's
Is this
correct.
Kagan?
Okay, so symmetrical.
Yes.
Correct.
I think it's
Okay.
Kagan.
What do you think? Suppose, you argue in your briefs that this law has viewpoint bias in it.
I don't know.
And suppose that that was accepted. Do you think that we should stop there? Is there any reason at that point to go on to say how in this particular context of medical treatment, we would treat a content-based law that is not viewpoint-based?
I don't think the court needs to address that if it finds that this is viewpoint-based discrimination. It reminds me of the distinction between this court's decision in Brunetti and then in Vidal. In Brunetti, there was viewpoint discrimination, and then when just content discrimination was at issue, the court treated it differently.
Thank you.
Justice Gorsuch?
Just quickly, back to the late-breaking standing argument, which is in, I think, footnote 18 on page 23 of Colorado's brief, and what your client intends to do. As I read the verified complaint, she would, consistent with the patient's wishes, explore changes to not just attraction, behaviors, and expressions, but also identity. Is that correct?
That's correct.
Okay, so even under Colorado's new reading of the statute, which is only about identity and orientation and not about those other things, even though the statute includes them, even under Colorado's understanding, your client would still wish to counsel people in a way that contravenes Colorado's present understanding of the statute.
That's correct.
Thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson?
So, as I understand it, the First Amendment protects the communication of messages, expression, etc. Am I right about that? I mean, you're communicating, and that's what the First Amendment is about.
Correct.
So I guess I'm still just struggling with whether a therapist who is acting in their professional capacity to help someone achieve their goals is really expressing the kind of message or expressing a message for First Amendment purposes. I mean, I understand if Ms. Chiles here were writing an article about conversion therapy or writing or giving a speech about it. But it's just a little puzzling to me that she would stand in a different position than a medical professional who has exactly the same goals, exactly the same interests, and would just be prescribing medication for that rather than her talking with the client.
I don't think that they would have exactly the same goals.
Why not?
Because this involves a conversation.
Yes.
There is a back and forth. So this court has recognized many times in cases like McCullen that a one-on-one conversation is a form of speech. And that's exactly what's going on with Ms. Chiles and her clients.
No, but it's also medical
when she engages
treatment.
in those conversations, she's encouraging them to achieve their goals.
Are
She's
they making the
discussing
argument
concepts
that
of
therapy
identity
is
and
not
behavior
medical
and
treatment?
attractions and how they fit together. This is an ongoing active
Then why
dialogue
be licensed?
where she's helping them to explore their goals, and that absolutely has to be protected by the First Amendment.
And you're saying the similar kind of exchange doesn't occur with the provision of other medical services that don't involve talking?
It certainly might occur in other instances, but
They think doctors
oftentimes
don't
there's
talk to their
conduct connected to
patients?
it. That's what's different about the medical context.
John, let it
And-
go.
And I'm sorry, can I just ask
I'm
you
covering
again what
Bosque
Justice
Board of
Sotomayor
Elections
asked, which
tomorrow.
is,
Come back for
why
that one.
wouldn't we send this back if you're right about strict scrutiny?
Because-
And let the lower courts apply that
Because
same-
there is irreparable harm going on right now.
What?
Ms. Chiles is being silenced. The kids and the families who want help, this kind of help that she'll offer, are being left without any
Well,
support.
then maybe
No, I
they should
understand,
move.
but strict scrutiny is not necessarily fatal, right? We have cases in which strict scrutiny was applied and it was surmounted. So why wouldn't we give the lower courts a chance to evaluate whether there's sufficient evidence here for the state to actually go forward with this regulation?
Because we were arguing for strict scrutiny in the trial court, so Colorado knew that was our position, and they had an opportunity to make their record. But the evidence that they submitted and the expert materials undermine their case. The expert
How?
materials admit that they don't have any study addressing precisely what's at issue, or specifically focusing on precisely what's at issue here, which is voluntary conversations between a licensed professional and a minor. Their expert materials also recognize that they cannot prove.
I'm sorry, I have to pause it right here. A voluntary conversation between a minor and a therapist does not exist. their parents have to, or guardians have to book these appointments, and they represent the patient. This is not voluntary. Sorry, that drives me crazy.
With their
I
religion,
apologize.
they're able to find deeper relationships with God. They're able
Doesn't
to
Colorado have some evidence that conversion therapy more broadly
I will be right
is
back.
harmful?
I
mean, I think there are like 25 states or something who have similar laws. So someone has some evidence related to the harmfulness of this activity, right?
Colorado certainly cites studies, but those studies suffer from significant flaws. The main flaw in all of them is that they lump together dissimilar approaches. They treat voluntary conversations the same as shock therapy.
Thank you.
Thank you, counsel.
Thank you.
Mr. Mupan?
Mr. Chief Justice, and may it please the court. Colorado's law is subject to strict scrutiny under the First Amendment for three straightforward reasons. First, the law restricts speech based on content and viewpoint. It prohibits petitioner from counseling minor clients to help change certain feelings and behaviors. It is thus subject to strict scrutiny unless an exception applies. Second, the law falls outside the exception for regulations of conduct that only incidentally burden speech. There is no separate non-speech conduct being regulated here. And professional medical treatment is not exempt from the ordinary First Amendment rule that strict scrutiny applies even to laws that generally regulate conduct, where those laws are triggered by the communicative content of speech. Third, the law falls outside any historically grounded exception. There is no longstanding tradition of states imposing this type of categorical prior restraint on the speech of therapists. I welcome this court's questions.
In the context of strict scrutiny,
Thomas,
how strong evidence would Colorado have to show in order to prevail?
Well, in this case, Your Honor, Colorado has no evidence, so I think
I understand that, but hypothetically, what would they have to show?
I think for this sort of sweeping categorical prior restraint, I think they would have to have very strong evidence that there was direct harm to patients, no countervailing benefit, along those lines before we could even talk about whether they can meet the very high standards of strict scrutiny. But again, this case is a much easier case because I think counsel will have to concede that if you look at the preliminary injunction record, both the three pieces of evidence that they put in, the Glass-Gold report, the 2009 APA report, and the 2015 SAMHSA report, and all the materials cited therein, none of them consider the type of speech at issue here. Speech by a licensed therapist involving non-aversive methods to minors. They just don't have any evidence of that. So certainly that's not enough under strict scrutiny.
Well, like, the evidence is not, like, make your claim on the First Amendment or don't.
Of conduct involved.
If you're already
Same answer,
arguing
Your
that
Honor.
they
I
don't
think
have
that if
enough
there is
evidence,
conduct,
you're
then
already
the question
admitting
would
that
be,
you may
is the
not be
restriction
right
of
either.
speech incidental to the conduct or the regulation of the conduct or not? And this court hasn't drawn a particularly clear line about when speech is close enough to conduct to be viewed as incidental, but here again, this is an easy case because there is no conduct. All that is happening here is speech. Now, there have been a lot of questions.
I would say that this falls under something very different, where this is speech that is also aligned with the medical treatment path. Again, that's my moral belief, but I think this is going to fall under they're violating her First Amendment.
You could breach the peace in the courthouse in California in a lot of different ways.
Right, but neither Cohen nor Holder involved medical treatment, right?
No, so that's true, but that's just a label, and this court has also said that labels don't matter in cases like Bunnin. There's nothing conceptually different. Take Holder, for example. In Holder, there was a statute that said, don't materially support terrorists.
No, I agree, it is
treatment. You can materially support terrorists in lots of different ways. You could give them money, you could give them guns, or, as in Holder, you could give them advice about how to commit their acts.
I understand, but when you look at the 10th Circuit's opinion, they talk about how there is a long historical tradition of regulation of medical treatment as a particular thing. The provision of these kinds of therapies.
Right, and the problem is the level of
Hitting
generality.
them hard,
There's
Jackson.
also a long historical tradition in this country of regulating contempt of court and breach of peace. But what there is not a long history and tradition in this country of doing is regulating contempt of court and breach of peace when it's purely based on speech. And if you look at the history that the other side cites here, what is totally
That was
absent is
horrifying
the
argument.
regulation of medical treatment.
Oh,
that
you
consists
didn't do it
solely of
before.
The federal government agree with Justice Kagan's flip side scenario. So it doesn't matter to you that we're talking about this is Chiles form of therapy versus gender affirming care form of
We
therapy.
do, and in fact, we think that's a strong reason in support of our position. Colorado's position, I think, inevitably leads to the conclusion that all the states in Scrimeti could have not only banned things like cross-sex hormones and prescription blockers, puberty blockers, but also therapy, talk therapy along the same lines. Even starker, in the 1970s, it was the standard of care, professional consensus, that being gay was a mental illness. So on their position, a state in the 1970s
He
could have
did
made
not.
it illegal for a therapist in the state to counsel a gay patient that they weren't mentally ill. That just cannot be right under the First
Can you
Amendment.
address Justice Sotomayor's question from before about whether we should apply strict scrutiny?
He just
assuming we think
said
it applies here, or
because
remand
y'all
it to the
ban
10th
gender,
Circuit to
or
do
you
so,
say
or the
states
United
can
States
ban gender
should say
affirming
so?
care in
Could
Scrimeti. Fuck
remand, but
you.
we think, like in Mahmood,
Yes.
this is a case where we probably fairly appropriate to actually just
Oh my
resolve
God.
the case here.
Why?
And for two reasons. One is there is ongoing irreparable harm to the
This
petitioner
is
because of the,
cray-cray.
restriction of their speech.
This
And the
guy's a
second is the
prick.
evidentiary record here
And he's
is
not hitting
totally
it.
clear that they can't satisfy strict scrutiny. If you look at the record on what's in the preliminary injunction record, there is just no evidence that this type of speech, not aversive therapy, not speech by non-licensed professionals, not speech to adults, but speech to minors by licensed
Okay.
therapists.
Do you have just last question from me? Standing, what's your position on the late breaking standing argument?
So precisely because it's late breaking, first of all, I think the most important thing is it's mootness, not standing. The question is whether there was a credible threat of enforcement for standing purposes. There clearly was, because as counsel said, if you match up paragraph 87 of the complaint with the statute, the conduct that petitioner wanted to engage in is clearly covered by the plain text of the statute.
I would say-
at most we're talking about mootness because the government has come
Oh,
in
fuck
now
his
and
mootness.
suggested
I
that
would
somehow
say
the plain
that
text of the
Colorado
statute
should
doesn't
modify
apply,
the law
or they're not
where
gonna enforce
only
the
a
statute despite
client
that.
of the
And we don't think that
therapist
in
can
these
file a
circumstances,
valid
when, the
complaint
state comes in
because
post-certiorari and
wieners
advances
just
a fairly
filing this
implausible
shit
reading of
because
their
they don't like
statute,
what it
that
says
should
on
be
your
enough to
Google
defeat standing. If I could
reviews
say one more
is
thing
also
about
problematic
how
for
implausible
this.
their reading is. As I understand their position, it seems to be that the language after including isn't independently sufficient. You have to be trying to change behavior orientation independently. If that was true, it would equally apply to aversive therapy. So if someone went into a therapist's office and said, I don't want to be gay anymore, I don't want to engage in same-sex conduct, if the therapist said, look, I can't change your orientation, but I can try to change your behavior, and I'm going to use electroshock therapy. According to the state, as I understand their position, they seem to be saying that that's not covered by their statute. I find that awfully hard to believe. And that just sort of underscores how implausible their reading of the statute is, and perhaps why it showed up on footnote 18 after the court granted cert.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
If we thought that this statute engages in viewpoint discrimination, does that have a bearing on whether we should decide whether it satisfies the applicable constitutional standard or remand the case?
I think it makes it even clearer why it fails strict scrutiny, but I think even as a content-based restriction, it pretty clearly fails strict scrutiny.
Thank you.
Justice Sotomayor?
Keep going back to the question of the studies and what's the strongest,
Sotomayor.
let's tick off. The thing that gives me pause in not applying strict scrutiny or in applying it is that none of the studies say that talk therapy is harmful. Is that correct? And Colorado,
For this type, for talk therapy by a licensed therapist to minors, they don't have any studies that say that that is either harmful or ineffective. And indeed, they often concede that they don't have that. The 2009 APA report expressly acknowledges at pages JA 221 and 256, expressly acknowledges
Because
that
the
they don't
Supreme
have
Court
evidence of
picked it
that.
up.
And if you look at the Glasgow Declaration, which is after 2009, she too doesn't cite anything. If you look at the studies that she cites in her declaration, all of them are conflating either aversive and non-aversive, or licensed and non-licensed, or minors or adults. They just don't have anything. And this comes up to the court after a PI hearing. And if the strict scrutiny applies, they bore the burden, and they just don't have anything.
Thank you.
Justice Kagan?
Mr. Mubin, you have an evocative example in your brief, which I want to pick up on, which is, let's say there's a school of psychotherapists that think that the best way to deal with suicidal patients is to go dare them to commit suicide. And you basically say, yes, strict scrutiny applies, but don't worry, it could be satisfied in a case like that.
I love the
And I just
TikTok
want you
shop.
to run through that and tell me why you think strict scrutiny applies and why you're confident that it could come out the way you think.
So I'll say a couple things about that, Your Honor. So first, we think strict scrutiny applies if the law was structured the way this law is.
Yeah, that's what I'm
So if it was a
assuming.
categorical prior restraint. So if it was a categorical prior restraint, we think strict scrutiny applies because it's content-based, it's not incidental to any conduct, and there isn't any history or tradition of imposing that sort of prior restraint. So we think you're in strict scrutiny. As to why we think you could satisfy strict scrutiny, because that type of speech has utterly no redeeming value. It might be the type of speech where you don't even need a study because it's so obviously harmful.
Yeah.
There's no real benefit.
Is that the right analysis? I mean, when I think about Brown, which I found one of the most difficult cases that I've ever encountered on this court, we really did insist, no, you need to have studies. You need to have a kind of scientific showing of causation rather than rely on your intuitions that, of course, this causes harm. And
Sort of my question
why
here-
wouldn't that be true in a case like this? And if it's not
They're
true,
talking
if you're
about
right,
studies.
are we
My
basically
question right
diluting
now
our
is,
strict scrutiny standard
does
in a way
this
that will come
side
back to
have
haunt
any
us elsewhere?
studies
So I guess what I would say
supporting
is
that
this, Your Honor.
non-affirming
If you were
care
not
is
confident in
beneficial
your
either?
judgment, then you probably should require studies.
we have any
But
studies?
if you were confident, and I think on a case like that, you probably should be.
If
it
this
would
is going to
enough.
be
But
brought
what
up
I
on their side, you
absolutely
better
agree
damn well have
that
it
you
on
should not
yours.
dilute strict scrutiny. It's important that strict scrutiny retain its rigor
Conservative
where it applies.
justice striking down this
But it's
lawsuit.
also important, as this court held in NIFLA, not to create additional exceptions to the general rule that content-based restrictions are subject to strict scrutiny.
NIFLA
And if you
was
take a step
about
back, the other
having
side
to
just
write
doesn't
a
have any
disclaimer that you
doctrinal
don't
or
provide
historical
abortion.
basis for getting this out of strict
Yes.
scrutiny. They can't say
That's
it's
why I can't
conduct
pause it.
because there is no conduct. They can't say it's history because there is no relevant history. All of their arguments would blow a massive hole in this court's case law, emphasizing that its treatment is inconsistent with Holder and Cohen, which
No.
says that the fact that you could point to some other law that generally regulates conduct isn't enough if the particular speech is what's triggering that content-based restriction.
NIFLA was about abortions.
Justice
This
Gorsuch.
case is about talk therapy.
Justice Kagan's hypothetical, could you point to a long history against assisting suicides?
You could,
I never said I
but
don't think
whether there's a
Skermeti
long
is
history
relevant.
of speech related to that, especially in a context where if suicide wasn't unlawful.
There have been
But
convictions for
could-
counseling people to commit
I think
suicide and encourage them to
Skermeti,
do so,
it was
and
14th
and maybe
Amendment.
providing a substantial step toward those have been all over the
It's
books for
not
hundreds of years.
subject
It's
to
true, it's a
heightened
little
scrutiny
trickier
under
because
the
I don't want to. I
Equal
agree with you
Protection
that
Clause.
that's a potential additional argument the state could make. I wouldn't want to leap to that because it would turn on things like
Speech versus conduct.
is suicide prohibited, so it's unlawful
No, it's
conduct.
not. No, it's
Right.
not. But assisting is. Most
Right,
states.
right, but so that then it's a little bit harder to say it's speech incidental to regulated conduct. And
I follow you.
even if suicide is illegal,
But
the degree of connection, it's, the incitement question under cases like
I want to make this point here that we know that in people who have gender identity issues, affirming care reduces suicidality. So if you're talking about doing non-affirming care, you are talking about an increase in suicidality. I just want to be clear about that.
Brandon.
Yeah, it essentially becomes an incitement,
Exactly.
and that is illegal.
Yeah, and I did want to make one other point to Justice Kagan, which is, I think another way of thinking about this, her question was about ex ante categorical prior restraint, but often this sort of speech, I think,
Always
would be
after the
quite
fact.
easy as a after the fact malpractice.
Yeah.
But I would like to say a couple of things about malpractice, because I think malpractice presents very different types of questions than this sort of law.
Because it's not prior restraint.
Yes, for three reasons. So the first reason is often malpractice is incidental to conduct. It's speech that's restricted, tied to some conduct. The second is, as Your Honor just noted, this is a prior restraint, and this court has recognized in a lot
The
of
talk
cases
is
like
the
Florida
conduct
Star
here.
and NTU
That's what
and
therapists
Madigan,
do.
that for First Amendment purposes, it's very important, the difference between letting someone speak and then adjudicating individually that speech after the fact, rather than categorically banning it ex ante. And the third and related point is, as a matter of history and tradition, we have a long history and tradition in this country of malpractice. Now, how that history and tradition cashes out for this type of speech is a tougher question, to be candid. But what is not a tough question is there is no history and tradition for this sort of prior restraint.
Thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson?
Can I ask you about licensing? You talked a lot about malpractice, but don't states tend
Jackson.
to tie licensing requirements to the standard of care? And so if we had a situation like this in which a state licensing board disciplined a doctor for a speech-based practice outside
You would
the standard
think,
of care,
Wallace,
that
you
doctor
would
have a
think.
First Amendment
But apparently
defense?
no.
So there is a long history and tradition in this country of licensing, and even licensing for people who engage in speech. What there isn't a long history and tradition of is, as a condition of that license, imposing a prior restraint on the types of speech they engage in.
That's
and we know from NIFLA
factually
that the mere
incorrect.
fact that there's a license isn't enough to obviate First Amendment review. Obviously, the whole point of NIFLA, it was regulating.
But NIFLA was a
You
notice
can't
scenario,
get up there
right? It
and
wasn't
tell
a
your
license
patient to
licensed
fucking
clinic.
No, I
kill
understand, but it
themselves.
wasn't
That
connected to the
restricts
provision
your
of
speech
services to
as a
particular
physician.
people. That was part of the analysis.
though goddamn
So I guess
sometimes
what I'm
you
saying
might
is
want
a
to.
doctor who's providing services pursuant to a
Sorry,
state
that's
license.
a little
I'm just trying to
hyperbolic, but I
understand
think
how
you'll get my point.
the First Amendment protects that doctor from providing therapy that is outside the standard of care.
Well, because in NIFLA itself, the
This is
court
crazy.
made clear that part of the reason it was rejecting a professional speech exception is because it was very worried about the risks of the state interfering with the doctor-patient discourse. And it gave us an example how in certain authoritarian governments, they do things like tell doctors you can't tell patients about birth control.
Sorry, guys,
Those
if they
people are
take
all
me down,
licensed.
I gotta back
And so
up,
if
cast the
there was some sort of
sequel.
argument that because you're licensed, all of a sudden the state can tell you what to say and what not to say to your patients, those very harms, the precise harms that NIFLA pointed to, could
So
happen.
can I ask you just one final question, just sort of from a very broad perspective? I'm wondering why this regulation at issue here isn't really just the functional equivalent of scrimetti. I mean, I realize that there were two different constitutional provisions at issue, but the regulations work in
Scrimetti
basically the
was
same
heightened
way,
scrutiny
and the question
under the
of
14th,
scrutiny
equal protection
applies,
under the law.
in both contexts. So it just seems odd to me that we might have a different result here.
Well, scrimetti was a law that regulated on the basis of age and medical treatment.
No, but here's what I mean, right? In Scrimetti, we had a state that wanted to prohibit certain medical treatment, gender-affirming care, being given to minors in the form of medication. And we said that was okay, and I understand there are particulars with respect to how the arguments, the constitutional arguments worked, but the state can prohibit that. Here we have a state that wants to prohibit gender-related medical treatment in the form of talk therapy, but we now have the First Amendment that is inhibiting the state's ability to do that. And I'm just, from a very, very broad perspective, concerned about making sure that we have equivalence with respect to these things.
Well, from a very broad perspective, there shouldn't be equivalence because obviously
Okay.
we have a First
Well,
Amendment.
why
so
not?
there have
Because
to be
talk
called
therapy,
speech.
Why
talk
not?
therapy, speech is what is at the core for you. It's
Right.
not necessarily the state's interest
The
in
talk is
protecting
the
minors from
treatment.
what it believes to be certain harmful
Right.
treatments.
Just like in Holder, the state had a very compelling interest in stopping materials.
If
for
talk
terrorism.
is the
Right.
But when you
treatment,
stop terrorism through
then you
speech
can regulate
versus
the
through conduct,
treatment,
The analysis is
Got it.
according to
All right, thank
Scrimetti.
you.
Thank you, counsel. Ms. Stevenson?
I think they're ultimately gonna rule this as a First Amendment, but I think it's regulated under, I think
Mr.
it should
Chief
be
Justice, and may it
regulated
please
under
the court.
medicine.
Throughout its history, this court has recognized that state power is at its apex when it regulates to ensure safety in the healthcare professions. Colorado's law
States'
lies
rats.
at the bullseye center of this protection because it prohibits licensed professionals from performing one specific treatment because that treatment does not work and carries great risk of harm. No court has ever held that a law like this implicates the First Amendment, and for good
Yes,
reason.
I think this is Colorado.
First, the law applies only to treatments, That is, only when a licensed professional is delivering clinical care to an individual patient. In that setting, providers have a duty to act in their patient's best interest and according to their professional standards. The First Amendment affords no exception. Second, because this law governs only treatments, it does not interfere with any First Amendment interest. It does not stop a professional from expressing any viewpoint about that treatment to their patient or to anyone else. And because Colorado's law regulates treatments only, and because it enforces the professional standard of care, the law falls squarely into the reasonable regulation of professional conduct that does not trigger First Amendment scrutiny. Petitioner's argument, on the other hand, cannot be reconciled with history, precedent, or common sense. A state cannot lose its power to regulate the very professionals that it licenses just because they are using words. A healthcare provider cannot be free to violate the standard of care just because they are using words.
Banger opening statement.
And a state cannot be required to let its vulnerable young people waste their time and money on an ineffective, harmful treatment just because that treatment is delivered through words.
That part.
Petitioner asked you to enjoin a bipartisan law passed by 25 different states, but she did not put one single piece of evidence into the record. Not a single expert, not a single study, not a single mental health professional willing to endorse conversion therapy.
That part.
And there is a mountain of evidence to the contrary. On this record, we request that you affirm the denial of preliminary injunction.
When I was speaking about the studies earlier and how they were bitching, they didn't have one fucking study.
Would this be protected speech?
So I wanted to mention our law covers physicians as well. They are also subject to the conversion therapy ban. But if you're talking about a non-professional, I think it would.
Well, she's not a non-professional. She's a licensed therapist.
There is a special relationship between a healthcare provider and a patient, where that patient is in a position of vulnerability and dependency
I don't think there's
on
a
the healthcare
preliminary
provider,
injunction on this.
and the healthcare provider owes fiduciary duties to act in that patient's best interest only.
In fact, I think the 10th Circuit said you're good.
Are there only healthcare providers who provide this sort of service?
No, the law accepts, I don't know factually if there are, but the law exempts religious ministers and ministries from this, and there is also a group of people called life coaches who could perform this therapy.
So what exactly transforms speech in that context to...
because speech is the treatment.
Speech that is protected in that context to speech that is not in the therapist context.
It is the relationship between a healthcare provider and the patient that establishes this special context. And again, if you go to a life coach or you go to someone else, they're not licensed by the state. You're not expecting them to be complying with standards of care. You have a different expectation. When you're going to see a licensed healthcare professional who owes you fiduciary duties, your expectations are different. You're expecting information that is complying with the standard of care, and not expecting the practitioner to just be exercising their right to say whatever they want to say. And that's just materially different, and it's always been treated so.
So what if someone who happened to be devoutly religious and actually relied more on the minister?
Well, you better get a new fucking counselor.
It would seem that person would be equally dangerous.
Well, I think that would be a personal choice that they were making to rely on their religious minister. It wouldn't be a representation from the state that this is a licensed professional who we are holding to a certain standard of care. And so the expectation, at least vis-a-vis the state license, would matter a lot. And in addition, the religious minister, just as a legal matter, doesn't owe fiduciary duties in the same way that a healthcare practitioner does.
Counsel, you said, just because they're using words, but our cases separate those out. Holder, NIFLA, in other words, just because they're engaged in conduct doesn't mean that their words aren't protected.
So, Chief Justice, our case is absolutely premised on the notion that communications that are happening in the very specific context of treatment, which I will call a licensed professional delivering clinical care to an individual patient, where they are subject to fiduciary duties and subject to malpractice, that is a fundamentally different regulation than a regulation of people out in the world going about their business, like at issue in Holder, where you have generally applicable statutes that apply to everyone. This is just a fundamentally different relationship. It has always been treated like that. In NIFLA, the court talked about the fact that
I think
longstanding
if you
torts for
have to
malpractice
apply
were,
for a
did
state
not implicate heightened First Amendment
licensing,
scrutiny, and I think that
I
analysis
think the
is
state has
exactly
the
the same
ability
here.
to regulate it.
Malpractice, you're dealing with that
Lawless.
same individualized relationship, and this is the exact same context.
For NIFLA, yes, there was a Supreme Court case on NIFLA.
What Justice Kagan called a mirror image question, and Mr. Mupon and Judge Hartz's example about homosexuality in the 1970s was professionally considered to be a mental health disorder. What if a state back then or might have passed a law prohibiting talk therapy that affirmed homosexuality? Would that be subject to rational basis review on your theory?
So, Your Honor, what our theory depends on is that there is a treatment being provided that's being regulated, and that the regulation is consistent with the standard of care.
Let's check both of those boxes in our hypothetical.
Then yes, and I want to return to Justice Jackson's point because
So yes,
they could
the
regulate.
state could forbid a regulated licensed professional from affirming homosexuality
If that were
consistent with the then prevailing standard of care.
That's right.
And
I
so
don't,
likewise, if the prevailing standard of care were to change or to solidify that this sort of talk therapy is beneficial to minors or at least not harmful to minors, then a state could pass a mirror image statute to Colorado's that prohibits any attempt to affirm changes of gender identity or sexual orientation, and that would be subject to mere rational basis review on your theory.
that's right, Your Honor. And just to illustrate, it's not the fact that there are words involved doesn't make it different. So states, like we recognized in Scrimeti, have the power to regulate even in the face of medical uncertainty. The laws or the standard of care could change there, and the legislature can act to change that. And
So
just
even in cases where medical uncertainty exists, you think that the state could pass such a law prohibiting ex ante speech that would affirm gender identity changes or sexual orientation changes or homosexuality?
I don't think you have to reach that question in this case because
I'm asking about the logic of your argument. And I think you just said states can regulate.
States
even
did
in
regulate it
absence of
before.
medical consensus in this fashion.
This
that
is not
right?
new.
where there are no
Just yes.
words involved and no First Amendment issue raised. And
I'm asking we're talking about speech and we're talking about therapy, talk therapy. That's what I want to get at. And I think you're saying that if there's medical consensus, the state surely could pass mirror image laws. And I think you're saying, but I want to make sure, that even in cases where there's medical uncertainty, the state could so regulate.
You could reach a holding in this
Ex
case
ante
that
means
said,
before
yes,
the
treatment
event.
is treatment, and this can be, it doesn't matter whether it's consistent with the standard of care or not. We would urge you to reach a narrower holding in this case.
I understand that, but I'm asking you to answer my question.
The Brunson brothers got turned down by the Supreme Court, you absolute
And we
dipshit.
normally provide, this court has many times said, when there's medical uncertainty, we defer to state judgments. And I think you're saying that yes, I think the logic of your position has to be yes. And I'll let you go as soon as you give me an answer up or down on the state of medical uncertainty and whether they could pass mirror image laws.
I think it's less clear that that fits into the historical tradition identified in NIFLA that calls specifically out malpractice, which is an enforcement of the standard of care. And while that question could come up in another day here, where we meet the standard of care, we don't think we need
Counsel,
to
it's
reach it.
pretty important though to think about how this would apply to cases down the road. So let me describe medical uncertainty as competing medical views. And let's say that you have some medical experts that think gender affirming care is dangerous to children, and some that say that this kind of conversion talk therapy is dangerous. Can a state pick a side? So it's not, I want to be very clear, it's not that the medical community says, we just don't know. It's that there are competing strands. In some states, like say Tennessee, which was the state at issue in Scrimeti, pick one side, Colorado picks another side. Your position is that rational basis applies?
Our position in this case is that the standard of care is important. It's important because that's been the
But
historical
like Justice
tradition.
Gorsuch said, just answer that question.
No, our view is that would not be
No,
the
that's
right
a good
rule here.
question.
One, because that's not consistent with the history and tradition identified in NIFLA. And two, because the reason why that history is important and the reason why the standard of care is important is because it's a confirmation that the state is not actually trying to shut down.
Okay, I'm not understanding why
viewpoints.
the standard of care, tell me, I mean, maybe I'm not following you. Are you saying that the standard of care, why do you think the standard of care question isn't relevant there? Because wouldn't that be a situation in which Colorado is essentially saying that the standard of care, that we're essentially looking at expert evidence and saying that we think this is what's appropriate, that we shouldn't have this kind of talk therapy, and Tennessee's choosing a different one as a matter of its state law? Or am I not understanding that correctly?
What I'm saying is where there is a First Amendment issue raised and the state can show we're regulating a treatment and we're regulating consistent with the standard of care, there is a confirmation, a security that the court can have that there is no other motive going on to suppress viewpoints or expression. And that's what's consistent with.
So Colorado's law would trigger a rational basis, but Tennessee's hypothetical law would be strict scrutiny.
If it were against the standard of care.
So there's no mirror image.
Counsel, can you define standard of care to help us? Is the standard of care a medical consensus about what should happen in the situation?
It's the same standard of care that would apply in a malpractice case. Yes, that is how.
So it's not a situation in which you have competing doctors and there isn't a consensus on what is supposed to happen.
Correct.
No, but I think you could have that. In my hypothetical, I'm saying that there might be a dispute in the medical community, is my hypothetical, where you have some experts saying that this should be the standard of care and others saying something different. That was the hypothetical.
Well, the question would be, is the regulation enforcing the existing standard of care? And you're describing a situation where it sounds like there would be many viable options under a standard of care.
Yeah.
Right. And so in that instance, I think that would raise more significant questions if there were actual multiple procedures, treatments available that all met the standard of care. And again, this is just a question that would be resolved exactly the same as it would be in a malpractice case where you could have, competing experts as well. And we'll decide, is this thing inside or outside the standard of care? If petitioner could put on an expert to show conversion therapy is inside the standard of care, then I think we wouldn't be here. That would be a different standard to apply to our law.
But they can't.
Question about how you're distinguishing Holder. It was a generalized law against
She waffled a little, but she's doing okay.
Terrorists, but you seem to be suggesting.
But I think Amy Coney Barrett had like a good question. What if there's like a 50-50 split in standard of care?
That said, it's a breach of your duty as a lawyer if you tell terrorists how they can break the law. That would be subject to rational basis review.
So I think that, again, the critical aspect of the relationship is that there is a duty between the professional and the receiver of the professional services. And it sounds like in the law that you're describing, Justice Sotomayor, there would be, the law is passed for some other interest than to protect the client in that case.
It's a good
and I think
question.
that's materially different. When we're talking about a special relationship where the client is depending on the expertise and training of the lawyer.
But I'm just not sure why that makes a difference. If we're talking about the speech aspects of it,
I'm looking at
why that becomes any less protected.
It's because that's how we've always treated speech between, especially in the healthcare context, between providers and patients. This has been an area that has been heavily regulated from the beginning of our country, and no one has ever suggested that a doctor has a First Amendment defense to say the wrong advice to their patient. And just to give an example on this speech conduct distinction, if I went to my doctor and had high cholesterol, she could tell me a number of things. She could say, come back next year. She could say, eat less red meat. She could say, I'm going to prescribe you a statin, or she could say, you need an arterial stent. And whichever way she violated the standard of care and making a wrong judgment there could be equally harmful
Shannon
to me.
Stevenson,
so I don't see how
believe.
you can parse out whether there is conduct involved in terms of when you're talking about professional services delivered in a fiduciary relationship where the client or the patient is expecting accurate information and information delivered to benefit their health.
I don't really see a difference between the argument that you're making now and the argument that I thought we rejected in NIFLA, that professional speech is a special category that's outside normal First Amendment scrutiny. But let me put that aside and ask about your interpretation of the statute at this stage in the litigation. And let me give you this example. Suppose an adolescent male comes to a licensed therapist and says he's attracted to other males, but feels uneasy and guilty about those feelings, and he wants to end or lessen them and asks for the therapist's help in doing so. Under your interpretation of the statute, is that banned?
So, Your Honor, our interpretation of the statute turns entirely on whether the purpose of the therapy is to change the person's sexual orientation or gender identity. If that
what is the answer to my question? Is that banned or is it not banned?
If the therapist told him or he asked, can you help me become straight? The answer would be it would be banned. If it was, can you help me cope with my feelings as to how I am and how I want to live my life? That's permitted. And all of that comes
why doesn't the situation that I've just described fall squarely within the terms of the statute, which says that conversion therapy includes, quote, efforts to eliminate or reduce sexual or romantic attraction or feelings.
Well, I would say that the goal of the patient is to convert.
If those things are undertaken,
that
with the
gets
purpose
more
of changing
problematic. But since the
orientation or
purposes
identity,
of this case
then they
are
violate the
minors,
statute.
That's not
that's
what your
more
statute says.
touchy.
This is the way we've interpreted the statute from the beginning of
But
this
an
case.
18
It's the way
plus
both of the
patient,
lower
if
courts
that is their
interpreted the statute.
goal.
It's the way every state that has this statute interprets it. And the reason why is because the harms from conversion therapy come from when you tell a young person, you can change this innate thing about yourself. And they try and they fail, and then they have shame and they're miserable, and then it ruins their relationships with their family or.
Well, I understand.
This is where the harm comes from.
I understand all of those arguments. What I don't understand is how you can square your interpretation with the plain meaning of the statute. Are you suggesting that everything beginning with the word including is irrelevant? You just want all of that deleted from the statute?
No, it's illustrative. And so, for example, one of the ways that people try to engage in conversion therapy would be by saying, look, you need to start dressing like a boy, and then that will make you change your gender identity. That's a way you could go about that. But if the minor wants to start dressing like a boy to match his gender identity, not because he thinks it's going to change.
That's just not the way language works. Suppose that there's a rule that says you may not bring any dangerous animals in the park, including pit bulls. Doesn't that definitively provide you can't bring a pit bull into the park?
Yes, because a pit bull is a subsidiary of a dangerous animal, but I don't think you can read an including to contradict the
How far does their
conversion
freedom
therapy
of speech
is an
go?
effort to change orientation or identity. If you read it to not mean that, then you've ruined that part
In a
of the statute.
professional standard of care.
I'm sorry, go ahead.
I was just going to say, I can't say I like meat, including tomatoes and celery. That doesn't make any sense. And that's how we read the statute. And again, have been consistently read this statute that way from the beginning of this case and every pleading that we filed.
If you recall the example that I gave you, I'll give it to you again because I want to contrast it with another situation. So in the first situation, an adolescent male comes to a licensed therapist and says he's attracted to other males, but he feels uneasy and guilty about those feelings. He wants to end or lessen them, and he asks for the therapist's help in doing so. The other situation is a similar adolescent male comes to a licensed therapist, says he's attracted to other males, feels uneasy and guilty about those feelings, and he wants the therapist's help so he will feel comfortable as a gay young man. It seems to me your statute dictates opposite results in those two situations based on the viewpoint expressed. One viewpoint is the viewpoint that a minor should be able to obtain talk therapy to overcome same-sex attraction if that's what he or she wants, and the other is the viewpoint that the minor should not be able to obtain talk therapy to overcome same-sex attraction, even if that is what he or she wants. Looks like blatant viewpoint discrimination.
As I heard your examples, I
I'm
think
gonna
they
be
would
right
both
back,
be
guys.
permissible
I gotta
because it didn't
use
sound
the
like in
bathroom real
either
quick.
case the goal was to actually change sexual orientation. And again, that's the touchstone because that's where the harms come from. And if there is no goal being reached.
I guess I had the same kind of question that Justice Alito had. I mean, if we assume, for example, and this is a big assumption on your part, but just assume that we're in normal free speech land rather than in this kind of doctor land. And if a doctor says, I know you identify as gay, and I'm going to help you accept that. And another doctor says, I know you identify as gay, and I'm going to help you to change that. And one of those is permissible, and the other is not. That seems like viewpoint discrimination in the way we would normally understand viewpoint discrimination.
I don't disagree with that, Justice Kagan, and that's why medical treatment has to be treated differently. Because anytime you exclude one harmful practice, you are by definition saying these things are allowed because they are not harmful, and these things are excluded because they are harmful. That's the driving force behind regulating the particular practice.
Let me ask you about the standing argument. There's a statute on books, and if it prohibits what the petitioner wants to do, why doesn't she have standing? Why is it an answer? Well, we haven't prosecuted her or anybody else under this statute.
I think it would if she said that she wanted to do something that violated the statute. And I think there's just been an ambiguity that has persisted in this case. What I can say is if she does not want to engage in a therapy for the purpose of changing a minor's sexual orientation or gender identity, then she is not violating the statute.
Well, both the district court, which ruled for you, found standing, and the 10th Circuit, which ruled for you, found standing. And you didn't cross appeal on those, and not that you had to, it's standing. You didn't even put a Roman numeral in your brief on it, or even a subsection. It's footnote 18 on page 23. That doesn't exactly suggest that you have great confidence in that argument, does it?
Well, we recognize we lost it twice. And again, it is the petitioner's burden, and it has been a persistent issue in the case, I think, in defining exactly what it is she wants to do. And to come back to this conduct
But
point.
if she does, consistent with a patient's, if I'm reading the verified complaint, if I understand that to mean, paragraphs 86, 87, that she wishes to help clients who voluntarily come and with the desire
I think they're going to rule
change
that
their
this is
behaviors,
freedom of
expressions,
speech
attractions, and
infringement.
identity, then that
This
would
is
give her
state
standing,
of Colorado.
wouldn't it?
Identity, yes.
Only identity.
The others not.
The others not because of your peculiar reading of the statute, but identity would. That would give her standing.
The change in sexual orientation or identity is the key to.
And that would give her standing.
That would.
Okay.
Because you're not disavowing that.
No.
Okay, so that settles the standing question.
Thank you, Counsel. Justice Thomas, anything further?
You rely on the history of regulating the medical profession quite a bit. What's the history of regulating therapists? When did that begin?
Right. So I would say
They are the
mental
medical
health and
professional.
healthcare delivered through words both were in full force at the founding of this country. At the time, that was done by people you might call physicians, and all of their practice was pretty much carried out through words and giving advice. As time went on and specialties developed further, and the mental health profession sort of came into existence, those same standards applied and governed psychologists and therapists. And then I would say the licensing of counselors as other professionals in the mental health field was sort of the second half of the 1900s.
With respect to this type of regulation that is a prior restraint on speech, what was the first example of that?
So, Justice Thomas, I want to push back on the notion that this is a prior restraint on speech. There's no enforcement of this law unless somebody files a complaint with petitioner's licensing board and she has an adjudicatory hearing and an opportunity for judicial review and all those things. So it's like many other statutes in that way. It simply calls out a specific practice that violates the standard of care. And those types of statutes have been around for a very long time. They were in the late 1800s. Those types of statutes governed medical professionals, and then have been added over time as the mental health profession has developed and govern mental health professionals in every state.
Justice Alito?
Your argument depends very heavily on the standard of care, which I take it is defined by a medical consensus. Is that correct?
That's correct.
I don't see one, Lois.
Have there been occasion? I mean, the medical
But there's
consensus
like
is
100
usually very
amicus
reasonable
briefs.
and it's very important. But have there been times when the medical consensus has been politicized, has been taken over by ideology?
We have no facts about that in this case, but I wouldn't disagree that that's possible. And I think it's a really...
Isn't it a fact that it's happened in the past?
I think
Three generations of idiots are enough?
I think that's certainly a concern. And if there were evidence of that in the record as to whether or not there were a standard of care that wasn't really based on patient safety, that would be highly relevant evidence.
Well, isn't that a reason to apply First Amendment scrutiny when what is being regulated is pure speech and not just saying medical standard of care, medical consensus?
That's the thing that drives
That's the
me
end of the day. Rational basis review, anything goes.
No, Your Honor, because again, when we're talking about words used to deliver medical treatment, those issues are the same whether you're talking about words being used or whether you're talking about medical practices that don't involve words. Those issues are the exact same.
Practice.
And there is nothing about this statute, for example, that stops anyone from sharing any opinion about conversion therapy or about how the consensus on that was reached. And again, in this case, there is just no evidence of any motive by either the Colorado legislature or any medical association to reach this conclusion on anything based on anything other than protection of minors and a decades-long record of research.
Was there a time when many medical professionals thought that certain people should not be permitted to procreate because they had low IQs?
I don't know that, but I will accept the premise.
Yes, it's eugenics. It's Margaret Sanger.
Was there a time when there were many medical professionals who thought that every child born with Down syndrome should be immediately put in an institution?
I don't know that, Your Honor.
Thank you.
Justice Sotomayor? Justice Kagan?
I could go back to your example about having high cholesterol and all the various things that a doctor could say. And I don't think like anybody wants to remove doctors from liability or any kind of professional sanction for giving utterly wrong medical advice just because the giving of that advice involves words, right? So if the doctor said you can lower your cholesterol by going out and eating dessert every meal, we would think that was like not a good thing for a doctor to say. And we wouldn't say, oh, the First Amendment has something to do with this. But I guess I have this feeling that that's a different kind of case, that is a case where the speech is incidental to whatever conduct it is that the doctor is offering.
I don't see the speech
you should take this pill.
I think the speech
or
is
you
either
should,
incidental and medical or it
these,
isn't. So
eating practices or so forth and so on. And are you saying that there's no distinction between what we're dealing with here and the range of things that a doctor can tell you in her office about what kind of care is appropriate for any particular condition?
I don't think there's any distinction because just like in the medical field, counseling is an evidence-based practice that petitioner trained for thousands of hours to be qualified to do. And her advice and counseling therapies, through her words, can be extremely harmful. And so there is no difference between that and the medical context. And I wanted to come back to the first part of your question about calling out a specific practice that violates the standard of care. This is a thing that legislatures do not irregularly. When you have a practice that although it's ineffective or although it's harmful, it persists anyway. So for example, in Colorado, there's a specific provision that says it's unprofessional conduct for medical doctors to prescribe anabolic steroids for sports performance. Now, normally something like that might die out, but you can understand why there are cultural pressures that make this continue to be interesting to people, even when they know there's harm. And this has been the problem with conversion therapy. Although every theory that it's relied on has been debunked and debunked and debunked, people continue to seek it and to want it and to believe that they can make this change. And I think that's understandable. It's a challenge to find out that you're a gay or transgender person. And then finally, to the issue of regulating a specific practice, we cited you a couple of cases about this false memory recovery. So there was a practice going on with psychotherapists in the 1990s where they were using a therapy that was causing children to come up with false memories of sexual abuse. And there were several malpractice cases.
Never read up on that
it.
case?
That therapy died out on its own. But if it hadn't, and therapists had continued to do it, and again, it was done only with words, surely a state could step in and say, that's unprofessional conduct. And that's exactly what Colorado and 25 other states have done here.
Thank you. Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
What is your best evidence on this record, thinking about the application of strict scrutiny, that this kind of talk therapy by licensed therapists to minors causes harm?
Sure. I would direct you, Your Honor, to JA 64 through 74. And I do want to note this particular argument about this specific study came up for the first time at 10th Circuit oral argument. And I think had we had an opportunity, we could absolutely have put in even more evidence to nail this down in the district court. But if you look there, our expert walks through all of the research that's been done since 2009. Aversive practices have not been in use since the 1980s or before. So all of these studies do not concern aversive practices at all. And then I would direct you specifically to the Green study and the Turbin study. The Green study looked at 34,000 13 to 25-year-olds who had gone through conversion therapy, and after controlling for other factors, found there was a 2 times rate of attempted suicides among that group. And in the Turbin study, Dr. Turbin looked at 27,000 participants. This was specifically on gender identity change efforts, including people who had received those efforts at under the age of 10. He looked specifically at childhood exposure and found association with adverse mental health outcomes in adulthood, including suicide ideation and attempts. This question about whether it's voluntary or not, that's just not an issue that had ever been raised to focus on. And especially with children under 10, I don't even know how you would assess that. I would also direct you to Dr. Turbin's amicus brief, though, where he further describes the techniques that he used in his study to show how much they would align with, I think, what petitioner would imagine that she would want to try to do. And then you have to put it in the context of people have been trying to do conversion therapy for 100 years with no record of success. There is no study, despite the fact that people tried to advance this practice, that has ever shown that it has any chance of being efficacious. And again, the harm from it comes not from the aversive practice. It comes from telling someone there's something innate about yourself you can change, and then you spend all kinds of time and effort trying to do that, and you fail.
But you bore the burden. She didn't have to show that it was efficacious, right? You had to show that it caused harm.
Right,
Yes.
but in light of 100 years of studies that all point in the same direction with no efficaciousness and evidence of significant risk of harm, we think we amply carried that burden.
Tell me more. You said that in the 10th Circuit, you wished, because if you had been back before the district court, you could have introduced more evidence. Did you not? It was a PI hearing. Why didn't you have the opportunity to introduce all the evidence you wanted to?
There was no hearing. We filed a response in response to petitioner's brief where she had no evidence. We put in a 60-page expert declaration covering all of this, and including not just the studies, but the fact that all of the theories underlying conversion therapy have been debunked. Initially it was homosexuality is a pathology that we need to treat. That's been debunked. Then it was homosexuality is caused by trauma. That's been debunked. Then it was homosexuality is caused by a relationship you have with your parents. That's been debunked.
So just on the very specific evidentiary question, are you representing then that if this went back, you want the opportunity to have a hearing to put in different evidence that it causes harm?
I think if there's some, argument that we need to show that these studies were done on people who
reverse
engaged in
and remand
voluntary
this
therapy.
bad boy?
I think you could potentially go to the study authors and get that. But that particular critique was never raised. And again, I just think if what petitioner is saying is you have to have a randomized controlled trial on children in order to establish with respect to the particular thing that she wants to do, that would be, I think, a study that would, not even medicine would require a study like that to come up with a standard of care.
Can we get into the rebuttal already?
Justice Jackson?
Can I just quickly get you to address Justice Alito's question about how you distinguish NIFLA? You have definitely focused very clearly on the special relationship, the professional context, and the fact that this is medical care being provided in a counseling relationship. But as Justice Alito points out, we have addressed
I fucking hate that they associated NIFLA with this
speech and the extent to which
it was similar,
it should be treated
but
differently, and it has
said no.
Case. So how do you distinguish that case?
So professional speech, as it was addressed in NIFLA, is a much broader category than what we're talking about here. It would include things professionals are saying in any professional capacity. We are focused on the very narrow context where a healthcare provider is delivering healthcare to a patient. They are under fiduciary duties to act in that patient's best interest, and they are subject to malpractice liability, and that is just a different category.
So you're saying that this is a very narrow.
I'm going to say this really carefully. I'll pause it real quick because apparently people are coming in here and getting mad that I'm talking. You know the reason I don't pause it? Because when I jump back in, we're going to jump ahead because this is live from the Supreme Court. And if you don't like it, you can fucking scroll. Thanks.
Thank you, Mr. Chief Justice. On standing,
sounds
Justice
like a skill issue.
In response to your question, I heard the state say that they are not disavowing enforcement, particularly if the effort involves discussions that seek change on identity. On pages 216 to 217, Ms. Chiles talks about how she wants to have full conversations exploring issues of identity and gender, and that includes considering change. On the issue of studies, there was a reference to the Green and Turbin studies. All of those studies relied on bias sampling, self-reporting. They conflated aversive techniques with voluntary counseling. They did not isolate licensed counselors, and they did not purport even in their own study to prove causation. Beyond that, Justice Thomas, in response to one of your questions, the state conceded that it would be speech if it was a life coach, but it's for some reason not protected speech if it is a professional. That is an attempt to revive the professional speech doctrine that this court rejected in NIFLA. This law's viewpoint discrimination is even worse than we've heard so far this morning because the state of Colorado would allow a 12-year-old without their parents' consent to enter into counseling that would go the opposite way on these issues of gender identity and sexual orientation. But if that same 12-year-old with their parents' consent want to seek counseling in the opposite direction, the kind that my client would provide, they are not able to do that. That kind of viewpoint discrimination must survive strict scrutiny. This law harms gender dysphoric kids because the statistics that we've cited in our verified complaint, as well as in the brief that we cited with this court, indicate that 90% of young people who are struggling with gender dysphoria before puberty work their way through it and realign their identity with their sex. But if one of those children go to a counselor and they specifically say, that is the help I want, realigning my identity with their sex, they cannot receive that help from someone like my client. Moreover, if they're continuing down the path of transition, then unfortunately they get locked into that path, and eventually it leads over 90% of the time once they start down the path of social transition,
where you can find information supporting their claims after this is over.
This
is just a rebuttal.
And lastly, there should be no remand in this case for all of the reasons that I just explained. In addition to that, I heard Ms. Stevenson say that they were aware below that we were arguing for strict scrutiny and that they had an opportunity to put studies in. So all remand would do in this case is continue to prolong the ongoing harm that's happening not only to my client, but more importantly, the kids who are struggling with gender dysphoria.
Thank you, counsel. The case is submitted.
Okay. All right. So, if you want to come up and ask a question, you're welcome to. I'll do my best to answer it. So, a lot of people were asking, does he have to prove the claim while he's talking to the court? Of course, he could cite where he got it, but when cases go before the Supreme Court, they submit a writ. They're picked up on a writ. And then a lot of organizations file amicus briefs. So if you put in your website browser SCOTUS blog and then the case name, which is Chiles versus Salazar, you will see a thing that says SCOTUS blog and it'll bring you to their site. Some of them, they write some articles about some of these cases, but you get the docket number and then you can scroll down and you can read every brief filed, the writ petitions, respondent petitions, and there are, if I had to guess, more than 50 briefs filed in this case. So it is a lot. They could have gotten that number from anywhere. I'm not going to go and find where they got the number because I'm not reading all these briefs. I'm not presenting the case. This is not my problem. The only thing I'm doing is just listening to it with you guys. But like you'll have things from like there's a brief from the Association of Certified Biblical Counselors. There's a brief from the American Psychological Association. So you have briefs from all kinds of different people across there. I only heard the last bit. Did the other conservative justices sound skeptical of Colorado's law? That's a good question. So yes and no. I think like judges generally enter this with a sense of skepticism. Even when you hear questions from like Jackson or Kagan or those guys, like they're always going to have an amount of skepticism in whatever they're evaluating. I think likely this is going to be a 5-4 ruling. For some reason, I'm feeling like Roberts may dissent. It may very well be 6-3. I'm not ruling that out, but I'm feeling for some reason like I'm interpreting a Roberts dissent on this one, but I still think this is going to be a 5-4 ruling in favor of this is her free speech. Even though I don't morally agree with that, I think I'm looking at legally this is what they're going to do. Yeah, I agree. So, yeah, that's interesting you bring that up. That's the Scarametti one. So they can do, they can ban the gender affirming care, but they can't ban conversion therapy. It's sort of an interesting dichotomy there. But yeah, Wallace, I'm thinking it's going to be a 5-4, but I'm not ruling out the 6-3. But I'm just feeling like I'm getting the vibe of a Roberts dissent. But again, I could be wrong. This is not great if they rule. I agree it's not great if they rule this way because it's ultimately, I believe that it's incidental because it's medical treatment. It is talk therapy, but talk is the literal treatment. So it's incidental to like the greater good of like their medical profession. That's why these are always interesting and complex questions of the law. I can say like on a legal basis, yeah, maybe this does fall more under a First Amendment, but I can also say that like the outcome is important here. What's up?
Hey, what's up? Like the First Amendment part, I see it, but obviously professionals have further restrictions in ethics and science beyond First Amendment. But the court said they shot that down in NIFLA. But when I read the quick abstract of NIFLA,
that's not what they did in NIFLA.
Yeah, I mean, I'd have to read the whole case, but did they go down that logic tree of professional medical care in a treatment environment?
If I remember, okay, if I'm remembering NIFLA correctly, NIFLA was I think it was an abortion related case to
California made them
treatment
put signs
centers in
up.
California. I think what they ended up finding was that making them put a disclaimer that they weren't some sort of certified center inhibited their speech or something. It was something like that. Hold
There
on.
were signs that California mandated be put in centers for state-funded ABs. And a pro-life organization said, we don't want to have to hang those signs up. It's against our free speech.
Yeah, it's targeted speech based on its communicative content are presumptively unconstitutional and may be justified only if the government proves they are narrowly tailored to serve a compelling state interest. Yeah, NIFLA was a weird case, which I didn't feel like it's oh, Davo, come up here, babe. I didn't feel like it's super sort of aligned with everything here. It wasn't really what I would have called an applicable precedent, because I felt like it dealt with really different things of the state demanding that you put this disclaimer on is not the same as the state saying, hey, you have to follow basic practices and good practices of, in a medical setting. I feel like the medical speech becomes incidental. That's my thing.
I mean, if your doctor can say whatever he wanted based on his free speech rights, that gets to be ridiculous.
And that got brought up in the brief, right? This sort of oh, well, can your doctor just tell you to go kill yourself? No, that's not something they can do because it's not a good practice. People will actually do that shit. So yeah, it's problematic. Saul Scamaro, I guess. I don't know. I don't know how to say your name, but what's up, buddy? Hello. Sal Scamaro, you're on TikTok live. Incoming. Hello.
Sorry, joined on accident.
Oh, okay. All right, buddy. Yeah, no, I just I thought the whole thing was kind of interesting. So,
but if you think about the Supreme Court 2025 justices and how they usually move along conservative lines, I would argue that opening up this conversion therapy probably goes against the conservative values more than it does to the conservative values.
Oh, no, because these are really religious people, so they're okay with conversion therapy.
Right, they're only in one direction, but this will open it up in both directions.
Exactly, won't it? And they were asking some of those questions. I think Jackson posed that question, and that was a good question to ask. Well, what if, we're okay with you converting the other way? Is that good too? Or maybe it was Barrett. One of them asked it. It was really good. And I was like, that's the question you should be asking. Chris, what's up?
Hey, hi, Cass. How's it going?
I'm good. How are you?
I'm good. I haven't seen you in a while. You behaving?
Yep. Did you have a question about the live?
No. I'm just here listening.
Okay, yeah, I'm just trying to keep it to just the topic tonight or today. Sorry, I'm so tired. I can't even.
Okay, yeah. If you want to drop me down, you can. I just want to say hi to you. I haven't seen you in a while.
Have a good one.
Behave yourself.
I will.
Yeah, I wish the question were more: can the state impose limitations on medical treatment without a good scientific basis? Because this is a political issue, not a medical issue.
I agree. And that's kind of the problem here, right? Is I think that it's probably going to be 5-4. I think they're going to say that this is her freedom of speech. I'm really hoping I'm wrong because of the fact that how far does this go? Really? How far does this go? Is the doctor going to be able to file that instead of amputating a patient's leg. They just wanted to see if, I don't know, fucking stones and rocks could revive the circulation. You know, like, how far does this go? Like, when does it become incidental? When does it not? I think it's really problematic. And honestly, I for real wish states wouldn't make shit like this, because this is gonna like sort of bolster this sort of bullshit. And like at the end of the day, if somebody's dumb enough to take their kid to this or go to this theirself, that sounds like a fucking skill issue for them. I've reached this point with vaccines and everything else where I can't fucking care anymore. You want to Darwin Award yourself or Darwin Award your kids? That sounds like a fucking skill issue for you to live with. You have to live with that. I know I should give a fuck. I know I should care more. I just can't anymore. People are too dumb and I'm losing my mind.
But this, and I was just going to bring up vaccines. This blurs the line between what is medically professional and what is the personal viewpoint of a provider. You know, so there were a number of doctors that refused to take COVID vaccines during the whole outbreak. You know, if you get one of those guys and they start telling you, well, I don't think they really do that, and you know, it's very hard to discern.
Well, now, and according to RFK, they can. So why should we this is why I can't care anymore. I have a government that actively thinks that like this shit isn't important, and I can't convince people that it is. So at the end of the day, I just don't know what to do anymore. I can't fucking care. If you want a Darwin Award yourself, that sounds like a skill issue. I can't help you with that. I do feel bad for the kids. That's what bothers me the most about this, is that they're coming at this from the premise of like, this is a consenting and willing adult. No, this is a minor. Minors cannot enter into therapy without parental approval. You cannot seek that type of medical treatment, at least as far as I know, if you're under the age of 18 without the approval of a parent. So what is this? This is parents putting their kids in this bullshit therapy.
Yeah, how old was the child in this case? Do you know?
There was no child in this case. This heifer just filed because she said, oh, it violates my freedom of speech, even though I'm a fucking therapist with a license and I'm being regulated by the state. Bitch, that's your job.
Oh, I thought it was a minor. I thought in the facts they said it was a minor.
No. I mean, she treats minors.
Okay.
She does. She treats minors and adults. So, like, but this is specifically about Colorado's, hold on, it's their minor conversion therapy law or something like that. It's something similar to that. Yeah, Linz, that's exactly my point, is that a child doesn't have a choice. Like, if their parent is demanding that they go, like, and parents set the goals with the therapist, is the client in this really setting the goals? That's the problem here.
But if they upheld Tennessee, don't they almost have to uphold this?
No, because Tennessee was built on the 14th Amendment and equal protection. It's not built on a First Amendment challenge. I agree, like it's they're like this, right? But like, since it's a different amendment that's being challenged, it could be a whole different like way that they set this up.
Okay, so the legal arguments and the mechanics may be different, even if from the outside it looks similar to us. Okay.
Yeah, it was built under it's not subject to, I think Scrometti was that it's not subject to heightened scrutiny under equal protection of the 14th Amendment.
But you'd think if states have the right to regulate gender-affirming care, whether they are pro or con, the state would hold that right. And these seem similar in that way.
Well, I mean, I think that they did bring up Scrometti a few times, but I think because this is arguing like a similar sort of framework, but with a different constitutional amendment. And since the First Amendment, if it meets the challenge, is subject to strict scrutiny because their the Colorado's opposition is it's only like rigorous, scrutiny. Like it's not subject to this like strict scrutiny. Is that if they find that it meets the elements of a First Amendment challenge, then you're fucked because the state is regulating your speech in their opinion. It's yeah.
Going to be an interesting term. They're already packing it with interesting cases. So
Yeah. Oh, I'll be live tomorrow for, I think it's Boss v. Board of Elections. I can't remember what state. Hold on.
and then Double Jeopardy is going on right now, right?
There's something going on right now. I just did, Illinois Board of Education or Board of Elections. Sorry.
That's tomorrow.
Yeah, tomorrow it's going to be whether petitioners as federal candidates have pled sufficient factual allegations to show Article 3 standing to challenge the state time, place, and manner regulations concerning federal elections.
I didn't catch all the standing arguments today. What was that based on? Why wouldn't she have standing to make this claim? The therapist.
I caught some of that, but I didn't catch why she wouldn't have standing. But like, I think that they affirmed, the Colorado did affirm that she had standing to make the claim.
Maybe without a specific threat and violation, there was no threat of prosecution, so she didn't really have anything to fight at the moment.
Maybe you could make that claim because since you haven't suffered any
Wrongdoing,
right? Like it could be argued, but I think like once you've reached the Supreme Court, it's probably valid that you have standing. But
well, that's kind of my argument. Like you took the case, you granted cert, like I'm standing here. How literal do we need to get?
They have come back and ruled sometimes that they didn't have lack of standing after they took a case. But yeah, it is sort of like interesting in terms of like a lot of times you don't see things being filed anymore unless there has been a victim. As far as I know, she hasn't been subject to like any sort of penalties. So we shall see. Let's see. Hold on. What are they arguing right now? I forgot what the other case was today.
It was something to do with double jeopardy, I think.
Barrett. Whether the double jeopardy clause permits 2 sentences for an act that violates 18 USC 924 and 924C and 924J, a question that divides 7 circuits about which the Solicitor General and petitioner agree, whether the Hobbs Act robbery qualifies as a crime of violence. A question left open after, let's see, I don't know. I wasn't super interested in this one because I think I read this cert petition and I was like, meh. But it sounds more interesting than it actually is. But yeah.
Yeah, I always like the criminal procedure cases. I always find them very interesting. At least the facts portion.
I hate the procedure cases. Like, I don't care. I'm just like, tell me what I need to do. Like, I don't care at that point. I'm just like, you know what? If it changes, it changes. Like, the one yesterday was super interesting because, like, in that case, it was sort of like, are you looking at, like, the Sixth Amendment, the First Amendment, or are you prosecuting Trump, or are you doing a Board of Elections case? Those are always kind of interesting for me. But yeah.
Cass, when you guys go to trial, at your firm, do you spend a lot of time in the courtroom?
Oh, I'm not at a firm anymore. I'm just a paralegal.
But you don't support a specific lawyer? Are you just, is it like project work?
I worked for attorneys, but yeah, like most of what I did was I worked for federal defense attorneys. So I spent a lot of time collecting things, delivering things, and making sure the client was communicated with. And there was not a lot of courtroom time because most of those ended up in police. I did a little bit of time in the courtroom, but not a lot.
In federal court.
Mm-hmm.
Okay, cool.
Well, don't let her lie to you like this. She is a bar certified doctor who gives financial advice on the daily.
So
She's been converting me for months, Davo. Don't worry.
I don't know. Somebody said go for the bar. I thought about doing law school. I could, but I would have to find something that has a not remote, like I can show up, but I have to I'm gonna apply to maybe like St. Mary's, and there's a few schools that do hybrid programs. Because I live in the middle of nowhere and I have kids, so going to law school is difficult.
Does Texas have like that apprentice route where you can work underneath an attorney and then get signed off?
I'm sure I could find an attorney to work under here. But yeah, no, I got to do like a hybrid program. There's a few friends of mine who know some good ones, so I may do that. I got to take my LSAT first though. So if anybody's taking it, study with me because I need help. They took away the puzzles. That was the part I was good at. They took away those damn puzzles.
Wait, is the bar or the LSAT literally just like a puzzle you put together? And
No. Okay, so they did logic puzzles. I was really good at those, but some of the other shits are like ridiculous. So, I gotta do LSAT prep. I gotta sit down and do it, and I just am lazy. But yeah.
Well, it always depends on the program score too, right? So.
Yeah, that's true.
I really hate to be this guy. Cass, what is going on with this particular case? I'm reading like whether law censors certain conversation between counselors and their clients.
So Colorado, an attorney in Colorado filed a suit challenging that their law against minor conversion therapy limited their freedom of speech, even though Colorado is saying, no, we're regulating the speech of healthcare practitioners. This is an interesting one because it's a conundrum. Is it in therapy, is speech incidental? Because in my opinion, it is, because it's a treatment. Like if the talk is the treatment, then the speech is incidental. So it's not subject to heightened scrutiny. However, I don't think that these ding-dongs are going to see it that way. I'm really thinking it's going to be a 5-4 split. I'm feeling a Roberts dissent in this, but it could be a 6-3 with ideological lines.
Yeah, that's problematic as fuck. If you're literally like a healthcare provider, you have obviously you have state regulations that you have to adhere to, and that's for the betterment of the health of the state. If you have a problem,
give me 1 sec. I'll be right back. Somebody's not here.
Devo, are you an attorney? I forget.
I am the furthest from, bro. I am literally like what you would consider a jailhouse attorney.
Okay. Well, I'm a YouTube attorney. Is that above or below a jailhouse?
That's way above, bro. That's way above. The only reason I'm good with idiomatal law is just because of my personal experience with getting in trouble. That's basically it.
Well, mine was growing up watching Law and Order. So when the Secret Service came to my house at 16, my mom knew to ask for a warrant. So
valid. Hell yeah.
Fucking Amazon. I thought somebody serious was here, goddammit. Yeah.
But yeah, doesn't she not have the position to just fucking move? If she has such a problem with it, I mean, understandably so. You have to go through new regulations and shit like that and probably get your license redone. But at the same time, how is that a limitation of your speech if you can just fucking go somewhere else to practice like that?
My problem is that, first of all, these are minors. These are minors that they're talking about. They're talking specifically about the law preventing minor conversion therapy. Now, if you are over the age, or if you are 18 or older, and you wish to enter into a program where your therapist works on aligning you with the gender you were born with, or you wish to enter into a program where your therapist helps you not have gay feelings, and that is your choice, not an issue. Oh, bye, Lawless. I have not one issue with that. However, if you are a minor, you cannot seek therapy without parental approval and involvement. So are these minors entering this therapy with their willingness to do this, or are they being told to do this? That's where I have an issue.
Right, yeah. Like, I was about to bring that up next. Is just like, obviously, like, when you're old enough, you can do whatever the fuck you want. But like, when you're going to a doctor, like, you can't just go to the doctor when you're a minor. You have to have you have to have your guardian, there with you.
Yeah. I mean, they don't always have to be with you, but like they're involved in making sure that you get treatment, and like, I don't know. I guess like I'm sort of on the side of like, I think that like they're probably going to find that this does violate her freedom of speech. But how far does this go? When does the speech become incidental, and when does the speech get to be regulated? Does a therapist get to tell their patient to go kill themselves? Like, can we regulate that? Like, is that cool? Like,
See, that's where I'm at with it. Realistically, is like I'm more on like, this is not in violation of free speech, just based off the fact of like, this is state regulation. This is a position of power. I was about to say a position of power, and then kind of correct myself, but it is a position of power. You are in fact, the medical provider in this case and scenario. Obviously, yeah, and that the whole, can you just go kill yourself type mentality type shit, that's the next problematic, because I know multiple fucking therapists that wanted to tell me that shit. Like,
well, I mean, I guess for me, it's just like, first of all, you're dealing with minors. There's parental involvement here. Like, if you are an adult and you want to enter into these programs, I am not going to stop you. I don't think that they're beneficial, but again, it's your choice. When you're dealing with minors, like, this can be more problematic than helpful. And like, again, I've gotten to the point where I've got with vaccines, which is like, if you want a Darwin Award yourself and your kids, I can't give a damn anymore. That sounds like a skill issue for you. Like, I know I should care more, but I can't. If people want to be stupid, let them stupid.
that's kind of just ultimately where I'm at too. Like there is government interest in doing a lot. Oh, thank you, Logic. There is government interest, obviously, in controlling like the health of the population and everything else like that. Yeah, this is problematic as fuck. This is a problem. And
I agree.
More right. I know you're more right with the like it's going to break down, and they're probably going to rule that it is a violation. But
no,
like,
I agree. Muddy, yeah, no, I agree that it does have significant impacts on kids' mental health and their outcomes as adults. What I found problematic that they did not bring up any like more in this is specific to like gender identity. We have study after study after study that shows that we see a reduction in suicidality when we you follow like a WPASS standard where we affirm and there's consistence, persistence, insistence, we see fewer negative outcomes in that. And so, but it's also to the point where like I've lost my will to care for people. If their parents want to do this stupid shit, their parents can deal with it. I fucking hate that I feel that way. But it's like I just couldn't be bothered to care. It almost makes me want to cry fucking thinking about it. I'm sorry, but I feel like an asshole. but I don't know what to do anymore. I really fucking don't.
It's picking the battle at this point. Like it's a battle that's just, it's not unobtainable, but just given the current situation and given everything else like that, it's rough. Like, there's virtually nothing that we can particularly do to change stupid shit like this. Neither of us are in Colorado. I mean,
well, look, I mean, the thing is, I would never take my kids to anything like this. Like, if I read that they did conversion therapy, I'd be like, any other therapist, any fucking other therapist.
Right. Oh, I got a guest.
No, I get it, Muddy. I worked in public health for a long time. That's why I'm where I'm at. Jeff, hi. You're live on TikTok.
Hello. How you doing?
Good. How are you?
Good. Yeah, one of my biggest questions, you saw it, I think you saw it when I wrote it in the chat, like, if, I don't get it, is conversion therapy implies that being gay is not a choice. So, but most Republicans and anti-LGBT people think that you choose to be gay, like that's lifestyle. So I don't get it.
Yeah.
Why are they fighting for conversion therapy if it's supposedly a choice?
Yeah, because they're fucking stupid. I just like to ask them when they chose that they were going to be straight or that they chose that they were going to be a man or a woman. They can never give me an answer on that. They're just like, oh, I was born that way. Fucking exactly. Exactly.
Exactly. Like I'm gay in Florida, and I'm just like looking at that, and like I'm just kind of like I see people say that they choose to be gay every single day. Like, yeah. So why is conversion therapy a thing? So I don't know. I never got a clear answer from people, and they don't know how to answer it. So it doesn't make sense to me.
Fucking stupid. Like
that's it.
Yeah, they're stupid.
I'm never getting an answer. There is no answer virtually. It's just all based in religious zealotry and just hatred of the other. I'm surprised that it's regressing the way it is, because it used to be, we were progressing towards gay rights and everything else like that, but now I guess somehow we're getting back into also stem cells being controversial again. I don't understand what the fuck is happening.
What?
Yeah.
Didn't know that.
Yeah. We're going back to like pre-Bush era.
Yeah, most of what because I'm in Florida, I've been seeing all the. Yeah, like since I've been like in Florida, the attack on wokeness and all that. I started more with DeSantis and Republican governors trying to enact their plan. Just like, okay, you're just making people scared of the LGBT community. Good job. It's not fun, but that's all. I appreciate you. Thank you.
No problem, Jeff. We appreciate you coming up, bud. Hope the best for you. I mean, it's scary times.
Yeah, I want to get out of Florida so bad, but financial crap. It's not great.
No, yeah, we want to get out of Texas too. We feel it.
But yeah, definitely good luck to you. Have a good one.
You too. Good luck and good day.
Simply like the idea of keeping. Yeah, this is. And honestly, like when I first read about this case, I'm not even gonna fucking lie. I was like, wait, that's not conversion therapy. Because like in my mind, like the way I had always perceived like conversion therapy were those like weird camps that they like send people to where they like sit them in front of like weird projectors and they have to watch like weird shit all day. And like, I thought of it like that. I never thought about it in like a therapeutic sense of like a 1v1 like that. I thought those like weird Bible camps, and I was like, oh my God, like it never occurred to me. And I that's probably that's a place of privilege because it's not something I've ever had to deal with, but yeah.
I want to be so for real. I didn't think it was anything more than that either, because I thought it was illegal for therapists to like engage in one-on-one that shit like that.
I mean, like, I guess just sort of like at the end of the day, what I think about is like, sure, if you want to do this, that's certainly a choice. However, we know that there are bad outcomes and increased suicidality for particularly for people who struggle with gender identity. I do not know the statistics on people who are gay or lesbian, but I do know for people who struggle with gender identity, we overall know that therapy and things like the WPAS standard with affirming care lower rates of suicidality. We know that. So I don't get this. I don't get it.
Prior to Obama, I mean, it was pretty bad. The rates, at least for the LGBs, and not the T's particularly at that moment, but like the L's, the G's, and the B's were in a pretty rough spot there for a hot while.
Yeah.
And then it just converted over to the T's, and now, yeah. That was what was really weird. Like, literally, like, none of this was ever a thing until 2014, whenever, Obergefell, and also what brought it to the masses was, I keep forgetting, Caitlyn Jenner. That was the first massively broadcasted person who had done a transition like that, and that anybody fucking cared. Yet, I mean, I'm not too on the side of Dave Chappelle right now, but he did bring up something very interesting whenever that whole thing was going on. Was it's interesting that, like, it was weird that everybody started caring immediately about that. Prior to that, you have Stonewall, you have other people who are, very trans individuals that moved the actual political compass and did a lot of other things, and yet all of a sudden it's Caitlyn Jenner, who also was very still problematic and continues to still be problematic in like a political sphere, very trans medicalist type ideology. So it's just it's weird.
I guess for me it's more like I don't see why people are so obsessed with that going on with other people. Now look, if it is your family, your child, your things, like I can see certainly like having interest in all of that. But as long as they're not hurting anybody, which they aren't, I don't care. Do whatever the hell you want. Do what makes you happy.
I think it's the argument that starts with the quote unquote indoctrination shit, right? Like they believe that sexual education is really teaching kids about fucking like, this is what happens when you have sex, and also just be gay as hell type shit. Like that, I think that's genuinely what they think. These are also coming from areas that typically have pretty piss poor sexual education in general. These are also places that you'll notice that have much higher teen pregnancy rates, as well as DV is everything else like that as well. But yeah, no, like just having the understanding of like your body is going through changes. These are what these changes mean is not indoctrination. It's literally just fucking helping a child understand what's happening to them during one of the scariest times of their fucking life. But yeah, so like the downfall I see is just like, since they can't really use that argument too much, but they can use like the drag people reading to children. Like they will always love to go to that shit. And I'm just like, do you think that just these drag queens are running out into like public areas and just like grabbing a book that's banned and just like screaming at children? Like what do you fucking think is happening? Like these parents are bringing their children to a drag show. Like we can have our personal disbeliefs about that part of it, but like the danger of a drag queen reading to a child is not the fucking part that you need to fucking any sort of way be concerned about.
My favorite part about all of this is these are the same fucking ding-dongs that are like parental rights, but it's only parental rights until it's something you disagree with.
Mm-hmm.
Listen, I passionately advocate for vaccines and did for many years. If you don't want to vaccinate your crotch goblin, that's your right. I can think you're stupid, but that's absolutely your right. But these people are like filing lawsuits. States are banning parents being able to get their kids treatment for things they fundamentally disagree with. Be fucking consistent. You want to be a fucking parental rights shitbag? Be about that life. Leave other people alone.
Such small government. Such small government. You gotta love it.
Yeah, small government. Even though we're going to make a law about everything, it's small government, guys.
Fucking 50 new governments, and we're going to make individualistic laws for each and every single individual possible.
Of course.
That's small government. I hate it here.
I hate the pocket on this shirt because they sewed it on all fucked up. It's Temu, so but like it's all fucking like under my armpit and shit, and I don't like the way they sewed it on. Fucking my other one that I have a gray shirt like this, the pocket's in the right place. It drives me fucking nuts. I keep looking at it. I'm like, goddamn pocket.
Just so like check it out. Just put like a speed stick in there, so that way whenever you have like the last second sweats, you can just be like, hey, like real quick. You don't even gotta like. You can all like
not a speed stick.
I mean, it's right.
God damn, Davo.
Just a little sneak attack.
I mean, you're not wrong. I guess maybe my tism is tisming, and I need to like take this pocket off. It's driving me nuts. But then it's gonna fuck up the shirt.
Oh, also, the only reason I'm here right now is because my classes got canceled today. Well, one class got canceled, and the other two don't care about my attendance, so I don't give a fuck right now.
Why did your classes get canceled? Bomb threat?
No. My English teacher is sick, and then my other two classes don't count attendance towards our grades, so I'm just like, I don't care enough to go today. I'm tired. I need to work, so.
Did you go to sleep last night? I fell asleep at like 9 o'clock.
I finally did. I had my alarm set at 1. I fell asleep at 9, and then I slept through my first alarm. Didn't wake up until like 2:30, and then that was too late to fucking like do anything with work. So I was like, fuck it. And then when I woke up for school, my teacher sent the message, and I was just like, well, great. My entire day's fucked now. Fuck it. Later, Muddy. No, I will say though, we've been having some wild shit happen on campus. I can't lie. It's been really different.
Thank you, Maddie.
I told you, you remember the whole dorm debacle that I was telling you about, right? And it's not like this was like a mass pew-pewing or anything else like that. I gotta watch it because like I know all these VC chats have like corrupted me. I have to watch my language. But yeah, this wasn't like a mass pew-pewing, but like the first day that they were doing.
I've been saying all of it. I haven't gotten banned yet. I'm just saying. I've been fucking letting loose, and TikTok does not seem to care, so I'm going to continue to do it.
Okay. So, like, there was a shooting at the dorms and shit like that, and it was just, like, an altercation between two individuals. It wasn't, like, anything serious, and it was in the parking lot of the dormitory. Mm-hmm. But, like, again, it's like really not far away from a bunch of places that did have some mass shootings, as well as like I just recently learned that apparently there was a pretty bad the El Paso mass shooter came from where I'm from. So
yeah, you didn't know that?
No, not at all. I didn't even know I forgot about the El Paso shooting.
Yeah, they drove all the way to El Paso, and part of the reason they did it, if I'm remembering correctly, sorry, I'm just going to put up a new background since we're not on the court stuff anymore. Part of the reason that they did it was because of Greg Abbott bitching about immigration. Mm-hmm. And after that, he was like, I'm going to tone down the rhetoric. So much for that.
Right.
Fucking bullshit.
Yeah, I literally, so in my entirety of like studying all of this shit, that one completely flew under my radar, and I had no fucking idea about any of that.
Yeah.
Which I feel kind of like personally, like a type of way about. I'm just like, God damn it, I need to do better.
No, yeah, that was the pew-pewing that Beto was like, goddamn right, we're gonna take your guns. It's probably the worst thing he could have fucking said, but he said it, so.
Yeah, like I will always concede that that was literally like the last time that he could ever been elected as the governor. But yeah, no, I thought he said that because of Parkland and his kids. Like, hold the fuck ass. I thought that was the reason why.
No, he said it because of the El Paso shooting, and it happened like a couple of weeks before he made that statement in a debate with Ted Cruz. And feel how you want to feel, but you don't make that statement in Texas. I mean, that's just political fodder.
Yeah, no, like that straight ass was like the worst possible thing he could have said. And again, like you can have your personal opinions about it, but again, if you want to be electable in Texas, that is the no word. That is the biggest no words. You, dude, like you should have seen our fucking faces. So we had a watch party about anything when it came to Beto in a local Discord that we had going for a minute. And we were all collectively, like, we heard that he was going to make a statement on something, and I was just like, yeah, let's watch it all together. And we all were on cam and shit like that. And then as soon as, like, he said, yeah, you're going to take your guns, we all collectively had that just, fuck. Like, we all realized, like, we're not winning this election. There's no possible fucking way.
Yeah. I mean, it was just like, it was one of those statements that, like, I understood his sort of sentiments. I understood where he was coming from in the moment. This was a few weeks after he visited a lot of these victims. I think they had like 20 deaths. I understood why he made the statement. It's just the sort of like premise of like being a candidate. You can't make that statement. Not here. Like now, if you would have been in, I don't know, Boston. Well, I think they're already banned there. That's irrelevant. But it would have been a different statement to make. But just in the climate that we have, you can't.
Well, the climate that we have. But even back then, like when the climate was a little bit even more like lesser and calmed down, like, and that was considered kind of like extreme, which I still find weird that I didn't know about it, considering how close it was. Yeah, no, like I agree with him as far as like the feelings of a father just being fed the fuck up. Yeah. Like I fully agree with him there.
Like one of the most banger statements he ever made, it wasn't that one. He was out there talking to people, and like even though he was talking about guns and like, you know, like I'm a very fervent Second Amendment supporter, but he said it with such conviction that it was like he didn't care what it cost him. And I will be like, okay, if you're coming at it from a point of like, this is something that like you're genuinely, this is how you feel. Like I have a lot of friends that feel differently, and I'm okay with them as long as their conviction is consistent, right? Yeah. One of the most like banger statements he ever made, he was talking about banning weapons of war. I don't call it that. That was his statement, not mine. But he had a heckler. Somebody was like heckling him, and he just turns around and with every sense of like, fuck you, he was like, it may be funny to you, motherfucker, but it's not funny to me. And he was so dead ass about it that like there was no way you were mincing his words. There was no way that you didn't understood what he meant. He didn't sugarcoat it. And I think like I liked that step as like for Democrats as being like very convicted behind what you're saying. You're not trying to dress it up. You're not trying to make it something it's not. It's this is something I'm passionate about, and I will call you a motherfucker and I will tell you to fuck off if you don't like what I'm saying.
No, 100%. And like that's why he almost won. Like he literally came so close. Wasn't it like 40?
It wasn't super close. He did better against Ted Cruz. But I will say like he lost a lot of momentum in Texas simply because of like him promoting gun bans. I think like had he never made the statement like he did when he was arguing against Ted Cruz, like, yeah, we're coming for your guns, I fully believe he would have really given Greg Abbott a run for his money. But like, it's sort of one of those, it was just the statement that sort of unalived his campaign.
I genuinely think he would have won. I don't think it would have been a run for his money. I think he would have won.
I'm not going to put it that he would have won, but I think he would have been closer to his Ted Cruz numbers had he not made that statement, if that makes sense.
It does. Like, so the whole reason why I say that is because, like, again, like, I hate always repeating the same shit over and over, but the Obama strategy of just going everywhere, shaking hands with everybody, you know, being a face everywhere. Like, there were Beto signs everywhere out here in the middle of the fucking, like, rural county Texas. Like, at the time, I think our population was maybe 3,000, and there was a Beto sign everywhere. Like, it's such an easy strategy, but at the same time, it's also a costly strategy. Because, you know, you have to go to, like, the VFWs and, like, you know, other public-facing locations that are more local to people.
I actually have a Beto bumper sticker that I got sent.
Yeah. And see, it was simple, like, and even his name made it easy. Beto for, you know, Senate, Beto for governor, like, just, it's a simple fucking name, and his name's a nickname, so it's kind of, like, catchy, because it's like Davo, Beto.
Yeah.
That was the thing that we had a conversation about, actually. It was funny.
Yeah, I think I should look and see if I got an email back from the Tallarico campaign. Like, I think Tallarico has some momentum. I, again, don't agree with all of his stances, but I think it's a campaign I can work for, so I'm gonna try to do that.
I didn't mean to unalive your numbers here.
Oh, you didn't, dude. Like, they've been up and down all fucking day. I went from like 50 to 200 and then back to like 65 and then back to like 180, and like they've been weird. It's just a Tuesday. I'm not worried about it. I've never been worried about the numbers of people that I get in here. If we're having good conversations, that's all I care about.
Valid.
If I were worried about numbers, I would be on top of TikTok by now, probably.
Fair. You know, it's as strategic as your ass can be with your tisms the right way.
I really should like try to do something on TikTok, but I figure like I'd rather just listen to these cases because I'm tired of people misquoting shit and being like, oh, I didn't know. Oh, you read an NBC article about this Supreme Court case and you want to talk about it? No, go listen to the fucking case. It's so easy. It's so fucking easy. So nobody that follows me has a reason to not know what's going on in these cases. I'm not going to cover all of them because some of them are frankly just fucking boring. But yeah. At least tomorrow I'll have a case, next week I'll have one, and then I have Trump's tariff case as well. So I think Frog said they were going to try to be here for the tariff one.
Yeah, Frog really wants to know about the tariff shit, as do I, honestly. That's going to be huge. That's going to determine what 2026 is going to look like, and it's scary.
So tomorrow is going to be Boss v. Board of Elections, or the Illinois Board of Elections. And then next week, next week I'll be doing the consolidated case that they're re-arguing about the Louisiana racial gerrymandering. It's Louisiana and Robinson versus Calais. And then on 11/5 is the tariff case set to be argued. They haven't set up any more dates, so through 11/5, I know what I'm watching.
Fair enough. Yeah, I know. I've been so into school that, like, I've barely been able to actually keep up, like, obviously. But
No, it's all good.
I've been trying to, at least. Like, him apparently, I just learned, is going to try to do what is it? He's going to try to pardon Maxwell.
I thought, that was what I was reading. SCOTUS refused to take up the Ghislaine Maxwell appeal. SCOTUS refuses Maxwell appeal. Hold on. They refused cert. Yeah, yesterday. Rejects Epstein Associate appeal of her conviction. Yeah. So they refused cert on that.
Right, and then now apparently the conversation is that Trump's talking about doing a pardon, as well as talking about a pardon for Diddy. This is where we're at.
I mean,
he can do it, sure. He can do it, sure. Fucking to the Macca's point, yeah, he can do it. Okay, cool. There's a lot of should he, though, in that. A lot of should he.
Yeah, well, I mean, ultimately, a lot of times, like I was talking about earlier when I started the live on the case, yes, these are questions of the law, but ultimately they come down to like a fundamental, just because it's legal doesn't necessarily mean you should do it. That's a lot of what these things come down to. Something can be completely legal. Doesn't make it right. Doesn't make it okay.
Yeah, I don't like any of it. I don't like fucking any of it.
No, I feel you.
Like, Ross Ulbricht, sure, cool. Like, I'm totally cool with him getting pardoned.
Oh, you know how I felt about that pardon. I was game. I was like,
Yeah, everybody.
Pardon him.
That was a total fucking game. If you were to fucking pardon Snowden as well as Assange, I wouldn't necessarily be too against that either. I could see the reasonings as to why you would want to do that for political points. Because obviously, as Assange, I call him Sausage, helped him.
It's okay. I call Mio Yiannopoulos Snuffleupagus. So
No, dude, that has been something I've called him before, and like I keep fucking up Milo's name because he has been out of my head for years.
I know, right?
Like, ever since he got fucking kicked to the RNC, that has literally been how long it's been, and that was 2013, 14, something like that.
It's bad when Republicans are like, you gotta go.
Yeah. And then fucking, well, to that point too, that's the same year that fucking Glenn Beck saw Richard Spencer was like, yeah, you guys should just go ahead and just like mask off, because like if this is the direction you're wanting to go, then just why are you kicking him out? He's going to be fucking speaking here next year. He was like genuinely mad about fucking Richard Spencer being there, and then sure
I would be mad about
Spencer was there.
I would be mad about fucking Richard Spencer too. Like, what the actual shit? Like,
but Glenn fucking Beck, of all people, come on. Like,
no. Richard Spencer is one of those people that, you know how I'm like, I will rarely censor just about anybody. I will rarely fucking talk shit about just about anybody. Richard Spencer is in the same category as Nick Fuentes for me. I fucking don't care what point you have to prove. People from the left reposting Nick Fuentes makes me fucking absolutely insane. I will not give that man a breath of air to breathe. Like, he could be on fire and I would not piss on him. Like, that is how little I care about him. And like, fucking Richard Spencer, same way. One of the best and only videos I've ever posted of something happening to Richard Spencer was when somebody fucking ran up on him and like beat the shit out of him while he was mid-speech in an interview. That is the only thing I've ever posted involving Richard Spencer.
Wasn't it? Hold on, I'm curious. This is old internet that I'm about to do, so hold on. I gotta close out of some windows.
Best fucking video, and they posted it with a remix of Blue Monday. Like, how does it? Yeah, fucking is so good.
Was it Richard Spencer that he was doing his like little? He's interviewed him multiple times. I know that part. I'm trying to remember because Nick used to go. So I think it was when he was living in Virginia. It was that house that he got fucking. They got doxxed at. And he was doing press releases, quote unquote, on his fucking front porch of his fucking house. And he would set up like a table, he would set up like a little like megaphone type situation with like a speaker and shit. And then like he would just have I need to remember who it was.
No, well, the one where Richard Spencer got the shit beat out of him was he was interviewing, I forget what building he was outside of. He was in like New York, Chicago, something like that. And fucking somebody from, I'm pretty sure it was like Antifa level associate, ran up on him and just started fucking pounding the fuck out of his face. It was so fucking good. I normally follow a very non-violent principle, but you know what? If I saw Richard Spencer, somebody's gonna have to bail me out of jail. I ain't even gonna lie.
It's just fucking crazy to me that like that was right where like the change started fucking happening. Was like like I keep bringing it back to 2012 to 2014 era. It's like literally right there because you had Milo, you had Richard, you had Nick blowing up, you had QAnon was big then too.
The Tea Party.
The fucking Tea Party is what led to a lot of this as well. Yes.
Well, I guess it goes back to like that sort of like we've had discussions about this sort of like free speech absolutism. I believe that the government cannot beat you up for talking some way. I believe that the government should not be able to charge you for talking some way. But I believe that if you want to talk a certain way and somebody wants to hit you, and I mean they'll face legal repercussions for that, assault charges, all kinds of shit. Well, fucking actions have consequences. I don't believe people should be unalive for their speech, but if somebody wants to fuck your shit up, well, bitch, motherfucker, that's how life works.
See, that's how they poise it, though, right? Is because they're viewing them being able to get the shit rocked out of them for saying some fucked off shit as a way of limiting their speech because they are in fear of having that speech in the public.
But it's not limiting their speech because the government is not doing it.
Right, exactly. Like it is a consequence of action. It is a public good to, capitalize on educating the masses in that sort of manner if they decide to indulge in certain things. The college, for example, was a really good example. The one where they chased out, I think that was in the UK. But yeah, no, like that was a perfect example of just like, yeah, like if he's gonna run in there and just say some crazy ass shit, hiling the certain man and all this other crazy shit. Like they were more controlled about it than I would have been, but at the same time, that was perfect. Like literally chase him out, make an example out of him, spit on him was hilarious.
I mean, so like here's what I like, and it's hard for me because I know I was like, I would probably fuck Richard Spencer's shit up, right? Like, but here's my thing. Like, the chasing him out, I'm cool with. Y'all literally walked his ass off the campus. I think it was pepper sprayed. I think it was spit on. I can't blame anybody for doing that because I don't know how I feel, but I'm just like, you're not, it's almost like you're so insignificant, you're not worth me going to jail for, if that makes sense. Now, I beat the shit out of Richard Spencer's face. That's worth going to jail for. I would take that charge and I would smile in my mustache. I would not care. But some little pussy ass bitch who came in and wanted to talk shit on campus, I would walk his ass out and then I would go back to class.
The craziest part is when I found that lady's fucking TikTok, and I found out like she's a sexual education teacher that's like super legit. Like,
I know. You sent that. I couldn't even watch it. I can't do that shit.
dude, it's actually really good. I'm not gonna lie. Like, it's actually pretty fucking decent. Um, she's actually given some real fucking like baller knowledge. I'm not gonna
You
lie.
picking up some tips, Stavo? I'm so glad.
I'm not picking up nothing. I'm validated. That's what the fuck I am.
Oh,
I'm
you're
fucking
valid.
validated.
Okay. Sure, Pookie. Sure.
No, dude, like she the missionary one was hilarious, yes. But like the purposing behind that one was because she's just like, yeah, if you want to do that, go for it. It's like encourageable, blah 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 blah. Put a pillow so it changes the angle. And it's like,
Davo, are you unfollowing Ari?
no, TikTok hates me.
Fucking kick your ass.
Ari unfollowed me too.
Rude.
Yeah, TikTok hates me. I will have moments where like, yeah, I'll unfollow a bunch of people, but I haven't had one of those moments in a long time. But at the same time, like every so often, I'll drop like 250, like 500 people.
Don't feel bad. He got big sad at me one time and unfollowed me, and I didn't even know until he followed me back. And I was like, "How you gonna unfollow me, motherfucker?" And he was like, "We were fighting."
I was, well, yeah, yeah.
Yeah, don't play. I don't even notice when people like unfollow me and shit. Like, I'm so out of that loop that I will not notice unless like I come up on you in a live and like I see that like you have the little plus sign next to you. I don't know. And if TikTok unfollows me from people, I would never know until they tell me. It's only done that to me one time, and I was like, I seriously didn't know it did this, but I'll follow you all back.
I
so don't pay attention.
I definitely notice because like as soon as I go to my profile, like I normally am stuck at like 10K following people. I'm consistently just following people.
I know.
But at the same
follow some motherfuckers, dude, because you can't follow more than 10,000.
I do. I go through and I go to like older channels that I haven't watched in a long time or have been banned or whatever the fuck, and I just go ahead and like get rid of those. But I'll do that. But at the same time too, I'm starting to think that my like recovery account that would be on like the TikTok server or something is whenever I had like 9,800 followers or following. And every so often, whenever there's like an update or some shit, I'll just drop like a mass amount of fucking follows. And it's just like particularly Democratic people that I follow too.
Gotcha.
Which would have been after like the election and all that other shit. So
I gotcha.
yeah, I mean, it's not, this is all speculative. I have no fucking idea. I really want to look at fucking TikTok's algo, but yeah, I've been noticing that too.
Oh, I should check my other accounts then. I got a few troll accounts, so I check those. I'm normally like, I only use my backups in my troll account if it's like a live where people that dox me are in there and I'm just nosy, or if it's like I'm banned on this one, I'll use my SQL account. But yeah,
I need to check out mine. I made a bunch of them, like just to have certain ones after RFK and everything else.
You should make yours like RFK's best buddy. You should make an account like that.
Well, what's funny is I actually made one. I was getting like everyone was making bird accounts because it was like crow and crow and everybody was fucking crow. So I was like, I'm gonna be mockingbird if this whole bird thing is gonna pick up. Like, so I made a mockingbird account.
I know
Which
bird
kind of
law.
fits.
I know bird law.
Bird law. But yeah, it kind of fits with the mockingbird because, like, I love the fact that one of my claim to fame is I got fucking Joel Patrick so fucking mad at his own voice for mimicking him back.
Actually.
Dude, I still can't believe I managed to do that, but that was fucking.
It's okay. Your name is still Devon Patrick in Monica's fucking Discord. And I hope you keep it that way.
I will never change it.
It's so good. Devon Patrick. Davo. Michael fucking Devon Patrick. Oh my goodness.
Republicans will run TikTok soon. I mean,
okay.
That sounds like policing speech, I guess. I don't know. I'm going with anything I can to make him mad.
I don't care. If they were on TikTok, I'll have more things to fucking report on, so.
I'm gonna go exclusively into Flat Earth Lives. That's what I'm gonna do. I'm just gonna start, if it's gonna be a Republican rant, I'm going full on Flat Earth conspiracy theory.
No. You gotta be a hollow earth conspiracy theorist.
Nope.
Remember, that's the only true earth shape.
No, I'm gonna be a globalist shill and still be flat earthing. You can't.
Fucking global shills. God damn it.
I still don't think any of them understand what a globalist even fucking means, including Steve Bannon. But they say words.
No, I'm sure he understands what it means. He just doesn't care. Are you all right, Davo? Dying over there?
No, dogs.
Oh.
Don't
All right.
out of the country. No, don't tread on me. I will, defend my land. So, Civil War, I guess, if you want, but I don't think it's going to go well for you.
I'll get right on that. I was thinking about hanging out in Cancun for a few years, being like a beach bum.
Bro, when I figured out how cheap it is to fucking live in, particularly East Asian countries that are not, specifically China, I'm just kind of like, You're telling me I can buy an entire goddamn house for $1,400?
So true.
I can't tell if Blue Eyes is friendly or not.
I have no idea. I don't know. You want to go to VC? Because I got to get off live. I've been on for over 2 hours and it's giving me the ick. And I don't have to work hard in VC.
No, that's fair. We can hop into VC for a little bit.
Okay.
I'm going to wait until, we can talk about it in VC.
Okay, love you, bye.
Bye.